Good morning. Welcome you to the second day of the Kenya School of Law 4th Annual Conference. Once again, my name is Naserian Sitelu, and I am pleased that you are here with us. I know that there are a number of us who are also online. I'd like us to start with a word of prayer, and then the national anthem, and then we can begin our program. Let's pray. Everlasting Father, we exalt your holy name. Thank you for allowing us to be here today. We ask for your guidance and your protection, and we pray that all honor and all glory may return unto you. In the name of Jesus, I pray and believe. Amen. All right. At this moment, I'd like to invite the Assistant Director, CPD Department, Mr. Isaac Kuloba, to welcome us to the conference. Sorry, I must have forgotten something. Please pardon me. But I will just welcome Mr. Isaac Kuloba to proceed with the welcome remarks. Thank you.
Thank you, Naserian. Good morning. I would like to welcome you once again to our conference. That's day 2. For those who are here and for those who are following online. Yesterday we had very vibrant discussions, starting with the chief guest, the data commissioner, who gave a keynote address. Then we've had a second guest, Major David, who also gave a very powerful speech on cyber issues. And thereafter we had discussions, panel discussions in the morning in this hall. Then in the afternoon we had 3 panels, actually, discussing different sub-themes. For those who attended, either physically or online, you agree with me that the discussions were very fruitful. The topics were very exciting. And actually the attendance was also very good. So we are hoping that this day will also be enjoyable as we discuss the issues, the topics that are lined up for today. If you look at the program, we have again a panel this morning. We'll also have divisions in the afternoon. And I would like to also inform you that the guest who was to speak to us, the president of the Law Society of Kenya, was to address us this morning, but he's engaged in another meeting in Naivasha. They are meeting the Senate in Naivasha, and he could not be able to join us. So his apologies are noted. Otherwise, feel welcome on behalf of the director, and thank you for attending this conference. I wish you all the best as we start the day. Thank you, Naserian.
Thank you, Mr. Kuloba. I need to adjust this. I'm a bit short. All right. For the benefit of those of us who are online, I will give you a breakthrough of how we will go through today's program. There are a number of adjustments, given that we have a bit of extra time. At this point, we will proceed with the substantive presentations, and a number of them will be happening online. We will begin with Dr. Kenneth Wine-Mutuma's presentation on the digital frontiers. You can see the details on your program. And then after that, we'll have a discussion by Mr. Nicholas Cheruiyot, who is here with us physically. Then we will proceed to Mr. Edridge Kanyaru's presentation, and then Mr. Kenneth Agira, who is also online. And then Arnold will be joining right after that with his substantive presentation. Arnold is with us here physically. And then Diana Mwai will come after Arnold Oginga, and Diana is online. And then we will conclude the substantive presentations with Caleb Weisiko Keraka. And then we'll give directions at every point when we will need to take the tea breaks and the lunch breaks. Therefore, I would like to welcome Mr. Kenneth Wine Mutuma. ICT will project and allow him to begin his presentation, which is happening online. Karibu, Mr. Ken Wine Mutuma. All right, pardon us for the few challenges we are having. It seems Mr. Mutuma, Dr. Mutuma may not be online to start immediately. We'll put him on alert and then we will proceed to the second presentation on the program, Mr. Nicholas, who will be discussing on the fourth sub-theme on legal education in the digital age. Mr. Nicholas Cheriot will have discussions on the topic on legal education in the digital age, embracing technology in the legal teaching and training. What's unique about Mr. Nicholas is that he was actually the only one to make a submission on that sub-theme. Therefore, he took on the greatest task that was presented before us. We must appreciate that. Let's welcome him.
Good morning, everyone. I hope we are well despite such an unfriendly weather, but I want to hope that we are all well, and that's to include the people who are joining us online. So as you've heard, my name is Nicholas Cheruyot, and in the next few minutes, I'm going to lead us in a discussion on the legal education in the digital age, embracing technology in legal teaching and training. And what I thought when I wanted to write on this paper, yeah, so what I thought when I wanted to write on this paper is because in most instances we are thinking about how law is transforming, how the future is transforming, and so on and so forth. Because there has been a change of how things are being done. And when we try and look 10, 20 years into the future, of course, there is going to be a tremendous change in terms of how we transact as human beings. But what do we think about that student who is joining first year, who is in their Form 4, they are doing their KCSE, and they want to join a law school? Do we have programs in place to cater for that student? Because as the circumstances in the society continue transforming, that comes with a different sets of challenges altogether. And for this person who is joining law school and who is studying law, are they prepared to handle these challenges? Are they prepared to help people maneuver through their challenges in the society? And so I'll be making a case for embracing the technology in legal teaching and training. And what I'm going to be doing here, I'm going to urge us that even as we embrace technology, we need to be cautious so that we don't interfere with the ethics of the legal profession, even as we do that, because we have we have specific ethics of the legal profession, and we need to be cautious so that we don't interfere with them in a way that will ruin the reputation of the legal profession. I don't know how many of us can relate with that, what we can see on the picture. Can start maybe on your left hand side. How many of us can relate to that? Oh, that's interesting. Seems like a majority of us. Maybe for the lecturers who are here, if today or 5 years now you are told to take a chalk and do what this, I think it's a lady, is doing, is it something that you are open to? We have a no here. Walim, is it something that you are open to? Take a chalk and go and write on a chalkboard, whether white or black or whether, yeah. Yeah, that's interesting, and I know even for most of us here, this is the setup that this is the classroom setup that we went through. And on your right hand side, you can see the library. You can see there are lots of books, hard copy books, and this is where you'll be told, maybe when you're studying, say, equity and the law of trust, this is where our lecturers would tell us to go, and we must go and find, I think, Snell's law on equity. The lecturer who was teaching us equity and the law of trust was telling us that I studied in Moi University. So my lecturer was telling us that even if you don't read Snell's law of equity, then just go and touch it. Just go find it in the library and touch it, so that I believe that maybe so that the spirit of what is inside that book can get into your system and your brain. So this has been the setup of our classrooms, and you need to have a hard copy material for you to study effectively. That's what we've been taken through, or we've been taught. So you find that there has been, in terms of teaching of law, law has been taught in two major ways. That's in a conventional way and in a Socratic way. And in a conventional way, you find that we have those lecturers who will be the monopoly of knowledge. I'm the one to speak, and you are the one to listen and take notes. On another hand, we have lecturers who will teach in a Socratic way. And in a Socratic way, this is to mean that a lecturer would pose an open-ended question, and then the students would engage. They would answer the question, they would discuss, and so on and so forth. But the main emphasis on this is still the use of traditional methods and modes of teachings, so that for this to happen, then we have to be physically, for this to happen effectively, then we have to be physically looking at one another. We have to be in the same physical environment to effectively do this. And you realize that even in terms of structure, most law schools have been structured in that manner. You can even look at the hall that we are in, because when you look at the hall that we are in for the people who are here physically, then you can tell that this is a very good, it may not be the most ideal one, but this is a good setup for physical engagement in terms of teaching and training of lawyers. The same case applies to law schools, which most of us attended. That is also the same thing. Also applies to our court system. So you realize that our courts are structured in this manner, so that for a long time you have to be physically present in court, and you have to file submissions in hard copies. You have to do everything in the traditional way of transacting. But you realize that there has been a drastic shift. That's no longer the case. And maybe to ask, probably for those of us who might have gone to a group of schools, who probably went to a school where you studied in maybe in this manner. I think the photo is on your left-hand side. Anyone? Either previously or we don't have anyone at the moment who is relating with this, where you don't have to carry very heavy books, but you can carry maybe a tablet or a laptop where you'll have everything inside there. Anyone? We have no one. Even Wakili, you even have your laptop here. Yeah, so I know we can relate to that. And then the second photo there, you can see that boy. He's so happy looking at the phone. And I know we can relate to this. When you go up country, children will be running for your phone, and they'd want to play a game, they'd want to go online, they want to do so many things using your phone. And currently, even you realize parents are using this as a way of I don't know what you can call that. Could it be, I don't know, corruption, or may not really be corruption, but you want this child to stop bothering you. So what you do, you just give them your phone, they'll be playing a game, and so on and so forth. So you realize that there's a drastic shift, so that the child who is attending class and studying presently is not the same as a student who studied in or is not studying in the same way as student who studied in the 1980s, 2000s used to study. So you find that these are two different groups of individuals, and realize that in the 21st century, there is now things have changed, and mainly this is due to the change in technology, and this is not only in terms of teaching and learning of law, but this applies also to the job market, where you'll get outside there and you are being told that we had discussions, substantive discussions yesterday about this on the same, where you have e-filing systems, you have e-payment systems, and you are no longer required to really file submissions physically, as the case used to be. And of course, this is product of COVID-19, not really in that sense, but COVID-19 showed us that there is a different way in which we can do things. Because during the advent of COVID-19, we were given a number of measures of combating this pandemic. And one of the best ways of combating COVID-19 pandemic was the restriction of movement, where you couldn't go to couldn't go to our classes, we couldn't transact physically, and so on and so forth. And you realize that there were so many distractions in terms of learning. Some of the schools even completely closed, and no learning was taking place. So you realize that we were in a disaster. And the best way to come out of this disaster as lawyers and law students, because I was also a student during that time, and I'm still a student. So realized that the best way of coming out of that disaster was adopting online classes, and some institutions were ready for this change, while others were not ready. They were caught unawares, and that's why some of them had to close and stop their operations altogether. The greatest lesson that we were able to learn from COVID-19 pandemic was that there is a different way in which we can do things. There is a way we can still teach and learn. Because this really changed our minds. It changed our perspectives in terms of the teaching of law. And, this is now where the place of technology and in teaching and learning of law comes in. So that whereas other institutions were ready because they had plans in place, probably they had foreseen that they had projected the future, and they had seen that this is where the world is headed, because truly that's where we are, and that's where we are still. Those are some of the options that we are still really exploring. And you realize that the technology occupies a very vital role in teaching and training of lawyers. So it occupies a very important and a central position in that sense. So what COVID-19 did was to just act as a catalyst, because I had said earlier on that some institutions were ready, and what they just did is to improve on what they had in store, and ensure that with time, of course, they are implementing what they previously were not in a position to do. So realize that this issue is the issue of technological changes and advancements have a huge bearing on how lawyers are being trained and taught in schools. And of course, this alongside that, this has an effect on the quality of legal education, so that as we talk about the delivery, because what we also need to remember is that this is a medium through which legal knowledge is being transmitted from the teacher to the students. So we need to be thinking of the quality of the legal profession and how we are going to ensure that even as we move online, we are still retaining the sanctity of the legal profession. And realize that there has been a recognition of that fact, whereas some other schools are still not recognizing this fact. And realize that there has been positive steps which have been taken by schools to ensure that they are moving with the moving tides, while others are still lost in a miasma of confusion, and they are thinking, should we go this direction? Should we just wait and see how the wind will be blowing before we make relevant steps? And one of the some institutions, such as the Kenya School of Law, they've taken a positive step. And at the moment, you realize that there is learning is hybrid, where there are people who are studying physically here in school, and others are studying online, and they are studying the same content. And this is what the Kenya School of Law has had to say in its 2023-2028 strategic plan. So what the school was saying is that the school continues to leverage on ICT in the delivery of its functions and the execution of its mandate. The school recognizes that in enhancing service delivery and to keep up with the ever-evolving technological demands, there is need for upgrade of the school ICT infrastructure. So the school has recognized that there is a need to upgrade the ICT infrastructure. And that's something which is very, very, very important. And it's something worth appreciating about the school. And then in this plan, the school purposes to automate and integrate its business processes, enhance cybersecurity, as well as enhancing capacity of the technical staff. So you realize that alongside that, there are issues which come alongside that. And one of the main ones, of course, is cybersecurity. And I'm glad that the school has been able to recognize this. And something else is to do with the capacity of the technical staff. And I dare add that it also has something to do with the capacity of the teaching staff. Because as you move online, do we have the relevant expertise to help us in this transition? Are our ICT personnel ready to help us in this pursuit? Are the lecturers well trained to ensure that they're in a good position to deliver the content via these online platforms? And you realize that, let me have a sip of water, just a second. So you realize that there has to be actions which have to be taken to ensure that we are seamlessly transitioning to these mode of teaching. And some of the actions which, of course, our schools need to do is one of them is an intentional investment in ICT infrastructure. Because for a long time, you realize that the schools or most of the law schools and training institutions have been budgeting for so many other things and leaving out their ICT infrastructure, so that you find that the schools are purchasing books, the schools are procuring so many materials, but in terms of ICT infrastructure, most of law schools and training institutions have not been putting an emphasis on that. So what we need to do is to be intentional and ensure that even as we make our budgets and everything, we need to bear this in mind. We need to remember that there are online materials to be procured, there are online systems to be enhanced, there are ICT staff to be trained, there are lecturers to be trained, and so on and so forth. And for this to effectively happen, then there has to be finances, and we need to ensure that we are putting in finances to cater for this transition. And something else is on, I've touched on this, is on human resource investment. Do we have the relevant ICT personnel to help us in this transition? And if we don't have, are we ready to take a positive step and ensure that we are procuring their services and we are procuring their services in this move? Something else which is important is law schools curriculum development, and this is so important because you realize that in our curriculums, they've been structured. Of course, they've been structured in such a way that it can be effectively done physically, as I said earlier on. But now that we are moving online, how can we structure our curriculum to ensure that we are effectively moving in this direction? And some of the ways, and you realize that this has been done in paralegal trainings, where we have I think ICT 1, which is being taught in the first year, and but now the challenge comes in law school, including our law schools and KSL, where you don't have a unit where lawyers are going to be taught how to transact online, how to ensure that even as we are churning out lawyers and advocates, they are ready to hit the ground running in the market. So we need to be thinking about this, and the main reason for this is that lawyers need practical skills, so that when you get outside there, your client won't be asking you to meet them on Zoom or Google Meet or anywhere, because we've seen these challenges. And someone else was talking about this yesterday, where he was saying that maybe if an advocate, of course, there are genuine concerns, but at times an advocate may not be ready to proceed. And what they'll be saying is that, my lady, my lord, I can't hear you. Can you hear me? Can you see me? I know advocates who are practicing can effectively relate with this, but at times there are genuine concerns. Someone has went to law school in the 1970s, 1980s, up to and we have a whole different setup altogether. This person doesn't even know how to install a Zoom account in their phones or in their laptops. So if we are moving if this is where the world is headed, are we training lawyers and advocates to be ready to solve problems and help their clients in such a setup? Because as I said earlier on, with the changing circumstances, there comes different challenges and problems altogether. So are we training our lawyers and advocates to be ready for this shift? And then you can see there we have a case of Strathmore University. And this is just an example of a number of institutions and what they've been able to do to ensure that they are putting in place mechanisms that will give practical skills to law students before they go to the market. And realize that there is a policy in Strathmore University where classes have to be done in a hybrid manner. So for a 3-hour class, for example, 2 hours could be physical, and then 1 hour is virtual. And as a lecturer, you must do that. You have to conduct your classes in that manner. So it's a policy which is in the school's curriculum. And you realize that there are also challenges which come alongside that, because there could be a student who is coming from Samburu County, Turkana County, Baringo County, and they are not they may not be in a good position to effectively attend classes, the online classes. So what the school has done is to ensure that as a student is joining first year, they are given a laptop, and the price or the amount for the cost of the laptop are to be deducted from the school fees that the student is going to be paying. So you realize that on the one hand, the lecturers are going to be obliged to do this, and on the other hand, the students and the parents are also going to be obliged to do this, so that a student won't say that I was not able to attend a class because I don't have a laptop, I don't have a phone. So you realize that this is just an example of what law schools can do to solve these some of these challenges. And so what this is going to do on the part of the lecturer and on the part of the student is that there is that lecturer maybe who was taught in a traditional way, and for them they want to use a chalkboard, and they want to conduct physical classes. So you realize that this is they are going to be very well catered in such a program. At the same time, if it's maybe a lecturer who is tech savvy, then you realize that they are also catered so that no one is being left out. And the same case applies to the law students. And then we also have an issue of law schools regulation standards. And you realize that this, because I had mentioned earlier on about the quality of the legal profession and the ethics of the legal profession. And this is now where the regulators come in to ensure that even as we move online, we are not interfering with the ethics of the legal profession. Because my professional ethics lecturer was telling us that law is a noble profession. They were teaching us how, and they were giving us reasons why law is considered a noble profession and not a career in that sense. So you realize that there are ethics of the legal profession, and we need to maintain them so that even as we use technology as a medium, we are not interfering with the quality of the legal profession. So these are some of the roles which have to be done by the regulators, including the Council for Legal Education and the Commission for University Education. and realize that there is something else that which have to be done by the regulators, so that even as because traditionally what the regulator has always been looking for is do you have the requisite infrastructure to teach law? And what they've been looking at or looking for is physical infrastructure. Do you have the lecture halls? Do you have a moot court room in your school? And so on and so forth. But you realize that the narrative is changing, and for the regulator, they also need to be up to speed, so that they ensure that even as we move to online mode of teaching and training, law schools are ready for that, so that as they look for, or as they look at the readiness of legal law schools and training institutions, they need to be looking at their ICT infrastructure. Are these law schools ready to adapt to the changing circumstances? And if not, then of course you realize that the Council for Legal Education and the Council for Commission for University Education have been given powers to even revoke the licenses of institutions which are not ready to effectively teach law. So those are some of the things which have to be done by these regulators. And then in terms of teaching methods, we also need to ensure that we are improving on the same. And the same case applies even to the students, because as you improve on, or as you transform the teaching methods, then in a way you're also transforming a method or a mode of learning for students. So we need to ensure that our teaching methods are improved in law schools, so that we move from traditional mode or way of teaching to the digital mode of teaching, but in a way that we are going to ensure that we are maintaining the sanctity of the profession. Then this should be done with a bit to ensure that as the global dynamics change, law students and lawyers are still in a position to effectively learn and use it to solve the modern day problems. Then this approach, in addition, because realize that of course there has to be mechanisms in place. A case example is what we are doing now, where we are using slides to maybe to even do this presentation. And the same case applies to classes, because there is a way in which you're able to effectively retain information when you hear as you see at the same time, rather than when you're just listening and there is nothing that you're seeing. So of course there are other aid memoirs which can be used to deliver content in while teaching law. Then we can also, some of the schools and institutions have embraced this, where you could play an audio or a video recording of court arguments and court proceedings, so that as you teach those students about, say, maybe as you take them through a civil litigation class or say trial advocacy, you need to show them how it can be practically done. And because I know we have plans in place to ensure that the students are engaged in an experiential learning, and you realize that this is be one of the mechanisms of ensuring that we are implementing that. And in one of the, because I'm a student here at KSL, in one of the classes, one of our lecturers while teaching us gave us a whole think, a whole 40 minutes to watch certain video which was touching on what he was teaching, and you realize that it was so interesting to just not take notes, but just watch what's going on, listen, and maybe you could just jot down some few notes for your own consumption. And realize that in the current, for the Generation Z, as they say, they can effectively retain content when they watch something of the sort, or when they listen to it. We can even see how music, how the contents of music can be easily retained in our minds. I know 70, 80, or even up to 90 or 95% of us here. I know there is a song which you can effectively sing from the beginning to the end without blinking. You can even write down the lyrics, all of them. And can we also look for ways and mechanisms of embracing this in teaching, so that we give them time to watch those court proceedings? We direct them to High Court, Supreme Court proceedings, so that they are able to see. They could even be given as an assignment, so that they go maybe find and watch a court proceeding, and then write notes on the same, and then come and present in class, or come and have a discussion around the same issue. So this is something that I've been personally doing, and of course, it also depends on the interest. But you realize that you retain a lot, so that even by the time you are going to read the judgment, you already know what's going to be featured in that judgment. And then there's something else which is on artificial intelligence. And you realize that there has been a number of technological advancements, and some people are now using artificial intelligence. How many of us are aware of ChatGPT? By show of hands. Yeah, I hope even for the people who are joining us online, I hope you are aware of the same. And maybe if you are not aware of the same, ChatGPT is a tool that has been developed, where which helps you in doing whatever you want to do. A case example could be, you can ask ChatGPT, and we need to be to know this, because it has an effect on the student. So an assignment can be given, maybe have 3,000 words on this topic. So someone can go online and then type, write for me an essay or a 5-page essay on the role of advocates in the society, and then the application, or whatever it can be called, will just do that effectively as you've commanded, and then someone will just copy and paste it, and then they'll submit and say that, Mwalimu, you gave this assignment, and I've done it in the last. You gave it 1 month ago. I've been researching on it, and this is my work. So the lecturer will be going to mark the assignment, thinking that the same has been done by the student, but maybe the student did it the night before, and then they submitted the same. And these are some of the conversations that we need to be having now that we have them, because it's not the only one. There are many others which have been developed, and as we Of course, we have people who are supporting the same, and we have people who are totally against the same. Of course, it could be for the reason that we need to, of course, as I said earlier on, we need to ensure that we are retaining the sanctity of the legal profession. But personally, these are my personal views that we don't have to shy away from this and even applying it in enhancing what we are doing. If it can simplify work that you would have done for maybe 3 months, then we need to embrace it. But at the same time, we need to take caution so that we are not violating the such rules. Says copyrights and so on and so forth. So you realize that these developments. This is something that is developing, but we are not ready for this. We don't have any legislation on artificial intelligence, and I think what we only have is a bill that has been passed. I think. It's been passed by Congress in Brazil, and then EU are also developing an AI Act, so that even as we move from the traditional way of regulating, because what this the effect that this has is it's of course it's going to be violating property laws and property rules. So that I'll have my paper, and how can you attribute what you have to me? Because as lawyers, we are being told that for every statement that you are making, then you need to attribute it to the order if it's not your own information. So traditionally, of course, we've been looking at copyright. When you look at Kenya, we have a Copyrights Act, but you realize that it's not effectively catering for these technological advancements, and we need to be ready for these changes, because as the society transforms, the law also has to be able to adapt to the changing circumstances. So the law has to be moving in such a dynamic way, so that as we have problems, the law has to be adjusted. Because I'm a proponent of the law being made for us, and not us being made for the law. So the law has to be structured in such a way that it will be able to help us in resolving our problems. So an artificial intelligence act is something that we need to think about, and these are some of the conversations that we need to push. And of course, there are technological gains. I won't spend so much time on this, because I believe that we are also aware of this, the issue of cost effectiveness of online engagements, access to a wide range of information and resources, and even time saving. Because currently or presently, you can be able to easily get whichever information that you want online. You can print it out and have it in a hard copy if you're someone who prefers hard copy materials. So, of course, there are pitfalls when it comes to this, and you realize that there are financial and other cost implications. And this has an effect on law schools and training institutions, and especially financially, because you really need to, as we transition, of course, we need a proper ICT infrastructure, and that comes with a financial implication. So, are we ready to budget for this and ensure that we are we are investing in this. So that's something that we really need to look at and push, so that we are not caught unawares, or as the lawyers are going outside there and advocate, they wonder this is a whole different world altogether. I'm not used to this, and because without finances, these transitions cannot effectively happen. So we need to ensure that we are purposely budgeting for them, and sure that we have the requisite ICT personnel, and even in terms of lecturers, we need to be training them so that they have the relevant skills to deliver teaching in these online modes. So as I come to an end, taking us back to the sanctity of the legal profession, as we make all these changes, we need to, I'll keep on reiterating on this, we need to ensure that we are maintaining the sanctity of the legal profession, so that we are not lost in the shifting tides, and the way Swahili would say that bendera hufuata upepo. So we don't have to follow wind. That in English will mean is to mean that a flag follows the wind. So where the wind blows, that's where the flag will be going. So as the legal profession, we don't have to be slightly moving with the moving tides, and then leaving our values and ethics behind. So let's be cautious as we do that, and in that again, the regulators will come in handy in as far as this is concerned. Then we also have bodies like LSK. So some of the objectives of the LSK is to ensure that we are still retaining our position in the society as the legal profession. And then as I finish, of course, this realize that this is something that we have to do, and it comes with a lot of implications, with a lot of challenges, and so on and so forth. But we don't have to shy away from this. We have to embrace technology in teaching and training lawyers. And but as we do that, we need to also exercise caution. And then once again, law schools have to be ready for this. We need to have finances in place. We need to train our ICT personnel, our lecturers, and every other person to be ready to do this. And there's a photo there. I don't know who has heard of this story of a bridge on River Choluteca. Any one of us who has ever heard of that? Wakili here has heard of it. It's only one person. Okay, so this is a bridge on River Choluteca, and you can see besides it, there is a river there. So that's River Choluteca. So that's found in Honduras, in Central America. So what happened with this is this bridge was built by a Japanese company back in 1990s, I think around 1998. And the reason for the building of this bridge was because there were so many floods which were affecting people around that area. When there were rains and everything, this river could overflow, and it would sweep away roads, houses, and so on and so forth. So a huge bridge was built on it by a Japanese company, and everyone was ready. Everyone knew that our problems have now been sorted out or addressed. We'll no longer have these challenges. But the rain, the season came, and there was a downpour, a heavy one, and the river, the rains did what it used to do previously. But now something interesting happened. Because there was a road which was so this bridge was joining one end of the road to the other. So what the floods did was to sweep away the road on both sides of the bridge, and then it changed the tunnel so that instead of going below the bridge, I don't know how you can have this, but you can see the water is the river is just besides the bridge. So what happened is the bridge remained there, just standing, and people are thinking, could we now that it's not serving its purpose, could we just demolish it altogether, or we can just leave it there? So they decided that we are going to leave it there as a monument. And the reason why they did this was to remind us, to remind all of us to always be ready to adapt to the changing circumstances. So that we saw what happened during the COVID-19, the advent of the COVID-19 pandemic. And for schools and businesses, which was structured in a traditional way, so many businesses died a natural death. And up to now, they are still yet to resurrect, and we are not sure whether or not they are going to resurrect. But we need to always be to ensure that we are ready for the changing circumstances, so that we are not caught unawares by the changing circumstances. And with that, I close my presentation, and I now give it back to Maureen. Maybe should direct us from here. Thank you so much for your time, and I wish you all a good day.
Let's give a better clap. Thank you so much, Nicholas. We may not be very aware of River Choluteca, but we have heard of the Kodak moment, right? Exactly, or Nokia. Just how technology shifted overnight. They did nothing wrong, except they did not change fast enough. So thank you for taking us through the impact that digitization has on legal training as well as legal teaching, and also attempting to see the responses that regulators may have to adopt in order to ensure that legal teaching is not being left behind. We appreciate that. Now we will head straight to Dr. Mutuma. He is now online and ready to do his presentation. Dr. Mutuma has over 10 years of as an academician. He is well known to some of us. We appreciate him. Let's welcome him with a clap.
Thank you very much, Maureen. I will start with the standard greeting for this kind of hybrid platforms. In court, it normally sounds like, "My Lord, Your Honor, can you hear me?" Here, I think it will be a confirmation to the panelists that you can hear me.
Yes, we can hear.
Am I still audible? All right, this is one of the interesting areas, of course, that we have to sort of live with when you're dealing with hybrid platforms. A very big thank you to Nicholas I am trying to share my presentation. For some reason, I don't seem to get it, but I will just proceed to speak straight to what I was going to share with the panelists, and my presentation will be appropriately circulated with everyone. I think the starting point to all of this is to sort of link with what Nicholas was saying earlier, that the digital space is growing exponentially. If you look at Kenya as a jurisdiction, and we have in many ways been touted as one of those Silicon Valley extensions within our region, you'll see our connectivity range, our access when it comes to penetration of ICT and digital devices. The extent of our innovations in this land has been one that tells us two key messages, that the next decades are going to be significantly different, and how we interact is going to be transformed exponentially. M-Pesa and various other apps that started all of this are a cup, a small ripple in the overall picture of what we anticipate to happen in the future. Of course, that expansion essentially means that there are impacts, and that's what I hope to share in the next few minutes, that there's going to be an impact when it comes to our fundamental human rights and freedoms. Technology has a dual impact. One, it can accelerate, it can enable the safeguarding, the promotion, protection, and the realization of these human rights. On the other hand, it has, of course, a manner in which it can exacerbate the violations of those human rights. In the next few minutes, I'll probably talk a bit about digital surveillance and commodification, and how this can lead to substantial impacts on various human rights because of very essence of those two terms, what surveillance does and what commodification does. In that discussion, I'll speak about surveillance capitalism in particular, a term that was coined to speak to this unilateral use of data for profit. But ultimately, the question that will be going through our minds is how we can, with this advancement in technology, ensure that we don't have serious violations to human rights and, by extension, democracy because of digital surveillance and commodification. So the first, of course, is in every conversation in this area is to realize that there is aggressive growth because of ICT. The digital space is growing significantly. It's cutting across different sectors. Everything in one way or the other is being digitized. Now, that's a huge conversation across all areas of law. We just heard about questions of pedagogy, the question of teaching of law and how it's undertaken, the different platforms. But even if you move into the substantive areas of law, this question continues to raise serious repercussions. So whether you're looking at international commercial law, whether you're looking at questions relating to international law itself, whether you're looking at criminal law, whether you're looking at the manner in which conveyancing and other practice-related areas of law is concerned, this aggressive growth and what it means for our legal industry is astronomical. For our purpose, of course, we're looking at the space of human rights, and particularly the avenue that it creates for advocates that exercise the defense of these rights. What does this actually mean? What does technology have the potential to do when it comes to the violation of those rights? Questions of censorship, online harassments, and in particular, these algorithms that are constantly being used to automate decisions and to come up with outcomes. So the first, of course, is in all of these discussions, at least as far as this paper is concerned, is to start with a conceptual understanding of this term surveillance and this very common use or commodification of data. Now, I teach the subject of national the state security and the law, and one of the most extensive discussions in that subject at the university, it's a postgraduate subject, is what surveillance involves. This idea of gathering, storing, analyzing data. Initially, of course, it was rooted in the state, and the idea was increasing an intelligence capability so that the state could promote safety and public order. Later on, of course, there is the idea behind it of making sure that that does not breach questions of state accountability and doesn't lead to an erosion of liberties and democracy as a whole. Of course, this comes in the backdrop that state intelligence programs will often delve into the personal realm of individuals, and they can be manipulated. It's not far-fetched, and recent history has shown how the state accesses the details of certain individuals that are either opposed to it in different fronts or at the center of protests. And the state, of course, then manipulates that information in its own political programs, and sometimes in the worst case scenario, to violate human rights and liberties. But beyond the state, I think the idea of surveillance has also emerged when you are looking at how such data of individuals in their personal realm has been used to profile highly sensitive information, information relating to someone's financial status, health status, and even more private realms like their sexual habits, sexual orientation, and so forth. Now, focus very much is on the state, but this discussion is in no way just confined to the state. Corporations are also in this space of surveillance. Don't need to say too much about Facebook and Google that employ surveillance to predict the users' preferences, what they like to consume. Delving into text messages, phone calls that the user makes, locations that the user has traveled. I never cease to get mesmerized by Google's faithful report back to me on maps, giving me a clear selection of the places that I've been, countries, towns, and so forth that I've visited. But beyond that, of course, Google is widely known as exploiting the power it possesses as a search engine, acquiring extensive information on what you're searching, what you're logging on, and being able to use that. It would be all okay to some extent if that information was used for the functioning of that particular company's services, but of course we know that it doesn't stop there. We'll speak about commodification shortly, but as far as the surveillance is concerned, a lot of that information is the honeypot for security agents. They tap into it. It is also used by thieves, by hackers, and so forth, to be able then to institute different forms of human rights violations. Now, the third is surveillance. I think of equal importance is a focus on commodification and what exactly this means once you are in the realm of the digital space. We have had that data and how it is treated is the new gold. Some talk about it as being the new oil, reference being made to the discovery of oil at one stage that astronomically changed the fortunes of the Middle East. And indeed, commodification is just about that, how digital data is treated, and particularly how it is sold and how it is traded for financial gain. Now, what essentially happens here is, of course, digital industry companies are using our data to manipulate and acquire competitive advantage. And the companies are in no way short in supply as far as this behavior is concerned. I mentioned Google, I may as well add Amazon, eBay, Spotify, Apple, and a whole lot of other companies. This idea of mining both data in the form of commodification and using monopolies when it comes to surveillance has coined this term, surveillance capitalism, by one scholar, Shoshana Zuboff, where he suggests that these companies essentially are unilaterally capitalizing on private human experience and using it to predict the preferences of these individuals through their behavior, and in the long term, transforming that into money or profits. There are, of course, extreme effects when it comes to these twin objectives that both the state and companies have, the twin objectives of surveillance and commodification. I think one of the areas we've seen this, of course, is in the question of electoral processes, electoral environments and contexts. Remember the polarized political campaigns in the US, Donald Trump era, the use of social media, how it was advanced to differentiate a targeted audience. We speak very much about an echo chamber, a bubble effect, where the advertiser, in this case, crafts messages that are to isolate persons with a particular viewpoint and to accentuate those viewpoints. This is exactly what was done by the infamous Cambridge Analytica 2018 saga, and how it used this digital space without the consent of users to direct conversations in a particular direction, in a particular way that ultimately led to a particular outcome. So we are aware of that. I think here in Kenya, we saw its influence in our 2017 general election, but by no means is it only confined to Kenya. I think other examples would be Brazil's election, 2018, Mexico's presidential election. There are quite a number of others, the Brexit campaign, and Cambridge Analytica was at the center of that. All of this, of course, is just to say, simply sketch a context, a background that in the long run, there is an impact. There's an impact on human rights. And that impact is underlaid by the mother, what many of us practitioners in this area to believe, the mother human right, that essentially gives birth to every other form of rights that we seek to protect and promote. And that is enshrined in Article 19.2 when we make reference to human dignity, the human dignity of individuals, and how that right is essentially positioned to realize the potential of all the other human rights that we will speak about. This position, I think, has been enunciated. I think the importance of human dignity as a right is enunciated very, very clearly in the UDHR, the Universal Declaration of Human Rights, and how it founds essentially all the other realizations and questions of freedom, justice, peace, socio-economic rights on the question of human dignity. To guarantee the realization of human rights, I think our constitution takes a huge leap from what we had in the past. In 2010, many have said it is crafted with the lever of Chapter 4 as being the essential character of the new state that is under that constitution of COK Kenya, Constitution of Kenya 2010 society. And that is a context in which the state has a duty to observe, to protect, to promote, and to fulfill human rights. One may want, of course, to look at the decision of Kenya Human Rights Commission versus CAK, Communication Authority of Kenya, 2018 case, where this is actually essentially what the court used to guide its ruling on whether the CAK had acted constitutionally when it comes to integrating a certain device that would allow access to the data of a subject's personal information. So essentially, if you start with that premise, one will realize that then across a scope of different rights, that we then need to be thinking about the digital space and its astronomical or enormous impact on each of these individual rights. Let's just cut through a few of them for given the time constraints that we have. I won't go into excessive depth, but I think a few illustrations will show what that impact looks like. The first, of course, relates to the right to privacy, a fundamental human right that actually forms the basis of several other human rights. That's the interesting thing about the rights discourse. These rights are an integral part. They're not divisible, but they interlink. And you will find, of course, the right to privacy is very key when it comes to the freedom of association, expression, freedoms against discrimination, and so forth. It's at the core of that. Certainly, the Constitution of Kenya makes it very, very clear that the right is clearly solidified in Article 31, and it gives every person the right, of course, to questions about property, questions about private matters, and so forth. It is at the center of the Data Protection Act, and I was very happy to see that the commissioner spoke essentially on that right yesterday, and that establishes the Office of the Data Protection Commissioner and the actual implementation of the principles that are given effect in Article 31. The concept, of course, of privacy at the very heart of it is to buttress personal information that is within a data subject's particular realm, and to make sure that that information is used within certain confines of that data protection subject. And it's not a new right. I think it has been with us for a while. When you look at different sets of relationships, and those relationships, whether it's attorney-client, doctor-patient, and so forth, illustrate why questions of privacy are extremely key. One, I think, essentially being the dignity of individuals. The other, of course, questions of vulnerability and cognizance of power asymmetry, that individuals may be in a position where the dominant power relations exist. Certainly, that is what we've seen in the country when we look at areas that have then called for legislation, and because of that abuse of dominance and power symmetry. Consider the CBK Digital Credit Providers Regulations of 2021, where mobile loan applications were noted to be particularly notorious for breaching the user's privacy. I think all of us at one time have been subjected to endless SMSs, text, and so forth, where the contact lists of our phone then find ourselves exposed to this harassment, including using shadow contact profiles. I think the heart of everything here, when it comes to privacy, is to ensure that requisite consent is obtained, and that consent is in principle really consent. And I say this because I think a lot of times we are in our use of the digital space come across different platforms where consent cannot be said to be sufficiently obtained, simply because for one reason you either accepted all options or you accepted an agreement with very scarce knowledge of the content of that what you're agreeing to, what you're consenting to, the very nature of the contract. Many times, of course, even the language in that contract, when you're on many of these sites, applications and so forth, might be broad, vague, or hyper qualified. So that is what I probably want to mention about that particular right to privacy. Equally important, of course, is the right to access, to access to information. Article 35 is your guiding force, of course. That was enacted principally to promote transparency and accountability of many public entities, state organs, and so forth. That article, of course, is buttressed by the Act, 2016 Act, Access to Information Act, which gives certain powers to the Commission of Administrative Justice to, as far as reviewing, oversight, enforcement of matters within the Act. Here again, I think we must be cognizant of the role that is played by whistleblowers when it comes to the promotion of human rights. Human rights defenders all along have been in a position to do what they can because they could access information, and using that information were able to disseminate it to relevant authorities and indeed to the public, understanding that the sovereignty rests ultimately with the people. Sadly, of course, I think when it comes to our reputation in this country as far as whistleblowers is concerned, we do not attain a very, very high mark when it comes to that particular grade. As far as what digitization and the questions of surveillance and commodification mean for access to information, we will see that that space has introduced certain limitations, including censorship through filtering, blocking of internet content, indeed questions about national security being used to influence the world of technology through surveillance and so forth. As I had mentioned earlier, that influence very, very often means that individuals are targeted, for what may be specific ads or content. Remember, this targeting in the past was confined to the state, but I think new discussions have started in this context when you're dealing with private bodies. We now speak of human rights not just being a vertical order, but also a horizontal order where those rights now can be enforced against private entities. And I think Facebook has been at the center of this idea of censoring and censorship and so forth. And then, of course, there is the use of algorithms that very often result in limiting the kind of information and the range of information that is available, because those algorithms guide content and personalize the search and the scope of what an individual is looking like, indirectly translating that to a limitation to access to information. The story, of course, can go on when it comes to this particular right, including questions of subscriptions to websites and whether those subscriptions and the use of premium accounts and money create some kind of digital apartheid, where some of us can access information and others can't. I'm very, very happy that I saw on the program someone was speaking to this subject, either today or tomorrow, what a few years many of us started a conversation on whether access to Wi-Fi and so forth is actually a human right. That conversation is no longer seeming to be one of luxury as times change and access now becomes universal. But for these purposes, of course, it's just to underline that when you bring in payment structures, fee structures, and premium accounts, you create some kind of digital divide. At the same time, all of these changes in the digital space have an impact, as you can imagine, on the question of freedom of expression. If we understand freedom of expression to mean the right to express one's thoughts, ideas, opinions, beliefs, and so forth without any form of restraints and censorship, it will be very, very clear what the impact of any limitation on that right would mean for a healthy democracy, where you don't have diverse thoughts and opinions. You are now looking at contexts like North Korea, China, where there is a deliberate attempt by government to restrict and censor and monitor any criticisms of the national order and so forth. Of course, you don't need government essentially to do that, as we've seen earlier. Even the very threat that you are being watched and there's some surveillance that's been put into play can act as a self-censorship of some kind, where subjects, individuals refuse to engage in expression of their own views because they are not comfortable that those views are appropriately protected, and that ultimately then has an impact on the freedom of expression. Similarly, when you think about the freedom of association, this right to join, form, or participate in different groups that's enshrined in Article 35, again, an awareness that my political affiliations and membership may be under surveillance and so forth, may refrain the very exercise of that right. In addition, there is the notion of digital profiling, where individuals are being targeted or profiled because of one or two attributes, whether for a modification reason or whether it's for a surveillance reason. And what that then does when it comes to the freedom to exercise this association that is given to them. Clearly, or rather acknowledged, not given to them, but acknowledged under Article 35. More recently, of course, we've seen the worst, the more ugly side to all of this. I sat on the political, the PPDT, the Political Parties Dispute Tribunal. At one point, we had cases which were a clear indication that many individuals had been compelled to join an association without their consent. I think there was an outcry by many citizens. Many of us may have caught it in the public domain that they were registered as political party members without their consent. And this was had particular complexities. You may want to look at some of the decisions of the PPDT in that regard when it was censoring the actions that were undertaken and attending to matters that now were essentially appeals from what the registrar of political parties had reached as a decision. Of course, at the same time, it's important to talk about the right to autonomy. Human rights assume an individual's freedom of agency and independence when it comes to their decisions and the actions they take. Here, of course, when you think about the digital space, that independence and freedom can be undermined in many ways by the introduction of automated decision-making systems. These systems, of course, lean very heavily on the concept of profiling, and they have been widely leveraged in traditional human-led activities, including in the area many of us are involved in, this alternative dispute resolution. When you're speaking about arbitration, you're speaking about the court systems and decisions that judges make, setting of bail, and the sort of risk assessments that are made that are constantly being turned over to the computerized world. The danger, of course, on all of this, once you start using digital algorithms and so forth that analyze users' data to predict the future, you may, in that process, create greater efficiency, but at the cost of the violation of human rights. Many times, these algorithms end up with unintended purposes, including racial profiling and making judgments and predictions on individual behavior in a manner that directly violates human rights. A few words also relating to international property rights. Article 41 deals, of course, with the right to property and, by extension, the right to intellectual property. The idea, of course, any IP lawyer will tell you behind intellectual property is that of incentive, that individuals that are at the behind the creation of certain products, innovations, and so forth should be incentivized and rewarded accordingly. Now, the problem, of course, is many of the AI algorithms, and I heard Nicola speaking about this, they rely on data from those individuals. And they apply that data often at the cost of those individuals and without rewarding them. I was listening to the conversation that Nicholas earlier made reference to on ChatGPT. That, in the long run, of course, can not just exploit a question of their intellectual property, but also questions around labor and exploitation. Remember, when we talk about those rights associated with freedom of labor, one is not just talking about harmful or unsafe labor, but you're also speaking about fair compensation. In close alignment with that, I think one needs to talk about commodification as a potential a breach of this right to freedom from labor, simply because we become essentially goods that are being traded without our consent. So it's a form of slavery, because our personal data is being used, our images are being used, and indeed they are being used to make astronomical amounts of money. Think about Instagram and different advertising revenues that have been generated on a platform of that nature, and all of it, of course, is running on us as commodities. I would want probably to direct participants and our good colleagues to simply look at a few comparative cases that are happening in different parts of the world. I won't go into them in great detail, but just to mention that because of the global impact and reach in this area, more and more we are being called to acquire lessons and indeed best practices from different jurisdictions. The one, of course, is the European Union. There's a lot of work that has been undertaken through the General Data Protection Regulations of 2016, the wording that is used around the necessity to acquire individuals' consent before their data is collected and processed is very, very key. At the same time, I think, and this is quite novel, is the right that has been granted through those regulations, not just to have individuals access their personal data, but individuals to have the right the right to have that data actually erased. Very, very novel. So the question is not just one of consent, but also the right where individuals deem it fit to have data that is within the public domain and within the hands of these entities forcibly removed because the individual so desires to do that. Of course, the EU, of course, places also restriction on the use of that data outside its terrain, and also has various other directives that might be useful for us to have a look at in terms of further engagement on this subject. Think about the e-privacy directive, again, that deals with the same principles around the use of cookies and making sure that they are strictly limited to website function and not abused. That privacy directive also deals with other new technologies that continue to emerge, and this is a very important issue when it comes to the digital space because of its dynamism and swift evolution. It also has references to the context of surveillance and when public authorities can use that data that's collected. Canada has also got some very interesting developments in that area. I think it has an act that formed the basis of discussions in many, many jurisdictions, the Personal Information Protection and Electronic Documents Act. It was quite ahead of its time, and it has continued to build substantially around that act, several forms of subsidiary legislation. Again, at the very center of that act is a question of consent when it comes to collection, use, and disclosure. And it has, very much like the EU, the right to access and an individual's right to correct their information. The EU goes further and it makes it very clear that not just that a right does not only extend to correcting the information, but also to being able to erase that information. Canada, I think, also was at the very start in deploying its Privacy Act in general terms into the area of personal information that was electronic. More recently, of course, it has the anti-spam legislation. All of us have been victims of this unwanted spam emails, and Canada has devised an instrument to make sure that that Canadians are protected from unwanted spam and electronic messages unless they give their express consent. Norway, of course, is very well known for its democratic ethos and human rights foundation, and for a very long time it has championed individual privacy rights. It has a personal data act, again, has molded around the same spirit of collection, use, and storage, requiring express consent. And it also has an electronic communication data act very much along those lines. In conclusion, I think it's key. There are certain things that emerge that are quite important as reflection points, closing reflection points. One, I think everywhere around the world, governments are being asked to strengthen privacy laws. I use the word strengthen because of, as I had mentioned earlier, the degree in which this area continues to change. What is fitting today is quickly overtaken by a series of technological developments. Number two, I think what's important in light of those shifts is an approach that sets out guidelines as government strengthens privacy laws, more principle oriented as opposed to prescription oriented. In other words, the letter of the law should be essentially overtaken by the spirit of the law. Again, this is because of the fact that we are in an area of unseen changes. Someone spoke some time back and was saying that we're living in a world today where we're using tools unaware of what will be required tomorrow. And then, of course, I think as in every case that we've shared around those comparative jurisdictions, development of the law should be user-centric, and there are far more examples that I have the time to speak to that have started on that premise. Lessons that can be drawn from the OECD principles, ISO, audit systems, the control associations under ISACA and SADC and so forth. But all of them are consistent. They start with the user and the protection of the human individual. And then, of course, they move into the creation of structure and standards. A closing remark when it comes to companies and this increasingly accepted idea of the horizontal application of human rights. Before, human rights was couched and developed around a vertical relationship where the state had enormous power over private individuals. That has changed enormously because more and more you are looking at private enterprises in many ways that are more powerful than the state. You may, if you get some time, want to look at the GDP of a country like Lesotho and compare it with the value of Amazon. I think you're looking at a comparison of about 1.8 or something billion versus a net worth of about 900 billion, 900 being Amazon and 1 point something being Lesotho. Those are dollars. And I think Kenya would be in the range of about 200 and something. So you have these massive transnational corporations, and they have completely changed our idea of who should be protected from whom when it comes to human rights. And of course, these companies collect, use personal data, And there is more and more a big discussion on how those companies should be regulated, including how they should encrypt the data that they come into contact with to prevent unauthorized access. But more than that, of course, the relationship between government and many of these multinational corporations when it comes to oversight needs to be rethought. The idea of whether they have sufficient muscle to investigate and sanction the companies is a huge discussion that has started. You could see the EU, as massive as it was struggling with only one single company in the recent spate of hearings that it had on the use and abuse of privacy data by Facebook. This means, of course, that governments now should work hand in hand because of this transnational nature of the digital space and develop linkages that can enable them then to be able to exercise the necessary oversight. One example, of course, is the Five Eyes Intelligent Alliance with the US, UK, Canada, Australia, and New Zealand, and so forth, essentially aimed at strengthening a better legal framework to regulate the collection, use, and the sharing of personal data. In the long run, of course, much is going to be won by each of us becoming aware of what is happening in this new world. Raising awareness amongst individuals is always going to score at the very, very top. I think much has to be done in the area of outreach by the Office of the Data Protection Commissioner. If we are going to recognize that while digital technology has the potential to advance, we must be very careful that it does not harm fundamental human rights and freedoms. Thank you very much. I trust that I've been audible. I will pause at this point. Thank you. Back to you, Maureen, Madam Moderator.
Thank you, Dr. Mutuma. You are perfectly audible throughout the whole presentation. And thank you also for your remarks on the impact on human rights that comes about through surveillance and commodification of our data. And also for highlighting some of the best practices around the world and practically what our governments can do in order to adapt and protect citizens' rights. At this point, we will welcome questions regarding the presentation by Nicholas and by Dr. Mutuma, and then after that, we can go for our break. So questions from the audience.
I don't know.
You may proceed.
Any preferred order, who to start with?
You can specify who you're referring your question to.
Okay. My name is Cornelius Lupao. Sorry for my voice. It's a bit shrieking. I'm a faculty member, and I have 3 questions for Nicholas and 2 questions for Dr. Mutuma. To Nicholas first. From your research and what you presented, you seem to recommend that the way to go is to keep digital in the learning institutions or for purposes of advancing learning. My question is, it has been determined that there is a possibility of having what you can quote unquote call lost students, in the sense that a student who is sitting wherever they are sitting logs in, and as long as it is showing the way it's showing there, that so-and-so has logged in, the lecturer or the management here will record that as being a log-in by that student, and that is in essence attendance. And yet that student can proceed to do other things. So from your research, have you come across any information which can assist learning institutions to take care of that? I would want you to respond to that. Two, as it's understandable, not all students have the same capacity in terms of access to devices of technology, neither do they have the same enabling environment in having aspects such as data for purposes of facilitating the learning. What do you recommend to the stakeholders to do? For instance, if it's ICT ministry, if it's, in this case, this school, to make it possible that if we choose to go that route and enhance, then we don't disadvantage some other students who may not have capacity to keep up with the enablers of the use of technology. Number three, I have come across some report which suggests that in two meetings of similar variables, in the sense that one, a meeting is conducted online, and another one, there is physical interaction. The level of concentration tends to be more for people who are interacting physically, and even the person giving a lecture, for instance, is able to gauge what to do when, where, based on the demeanor of the recipients. If we were to go the option of the online classes as you recommend, how do we then ensure that there is optimal benefit by the recipients, in this case the students? And how do we also ensure that the lecturers have proper engagement to ensure that high impact to the students or to the learners? To Dr. Mutuma, we have had situations specifically in our country where the state takes some sort of refuge in what it calls, quote unquote, national security, and therefore it wants to forcefully obtain data from citizens in the name of saying we are going to use this to either populate necessary information in order to take control of issues of national security and all that, so that it becomes compulsive for the citizens to seed that data. And in essence, a citizen has no choice but to give a lot of private data sometimes in terms of what they require. What recourse does a person who wants to cut his or her space in terms of not having my private information and data given out there to the authorities, and which they can use to do other things other than what they are alleging to be a national security issue? Then the last question to Dr. Mutuma. I think if you answer the question I've asked, you can take care of the second. They are more or less correlated. Thank you.
Thank you. We can take one more question before they respond. There's one in the middle.
I am Chirimi Matagasia, and I'm thankful for this opportunity to be here. I want to build on the question that my senior has directed towards Mr. Cheriot with regard to online learning. For example, as a student of Kenya School of Law, I registered for physical classes, but in the recent weeks that there have been demonstrations, we've been compelled to attend some classes online. So isn't that an infringement on the contract that I entered with KSL? Because I was here for physical classes. For reasons that might be pecuniary, maybe I do not have internet in my house, I do not have a smartphone, I cannot access online learning. And if you must attend at least 75% of your classes. So if I were to claim that by reason of being forced to attend online learning and I have no access to online capability, that is what put me under the 75% threshold. How would the school respond? Because even if you look at the 2021 KSL regulations on online questions, they've addressed some of the issues that you've addressed. They say that you should have a live image, not as it is being seen over their initials. They say the image should be live. I think that's regulation number 7. You must have a live image. So even I can just claim that the classes in and as they have been constituted online are moot because they do not follow their own regulations. Because the few classes I've attended, only the lecturer has a live image. The students are initialized. That's to Mr. Cheriot. Then the other 2 questions are to Dr. Mutuma. The first one is with regards to ChatGPT. He talked about the human dignity aspect. And there was this expose by the Times newspaper sometime in January. I do not remember the exact date. And I apologize in advance due to the crass nature of the content I'm about to share, but it speaks to the nature of my question. They found that Kenya, there's a farm in Kenya. I do not even remember the name of the farm specifically, but it was hiring Kenyan workers for under $2 a day to, they call it artificial intelligence, but there's no mind behind the computer. It is actually human beings who learn the intelligence that is called artificial. So among the things that these Kenyan actors were found to be, this is naomba msamaha, but they said there was an actual quote that an individual watched a video of an adult having bestial relations with a dog in the presence of a child. So what are the implications of, because under the Sexual Offences Act, that constitutes as child pornography. What are the protections that I, as an individual who has been subjected to that information, I was not planning to see it, but once you are found viewing it, you're in possession of child pornography. So what protections does the government have for me as a third party to that? And then has the government failed in its duty to protect the human dignity of its citizens? And then the final question to Mr. Mutuma too is the legality of virtual private networks, because they bounce your API. So how does the government view virtual private networks? Thank you.
Thank you for those very critical questions. I'm also wondering what's my protection against you bringing that information to me. All the same, let's have Mr. Cheriot respond, and then we have Dr. Mutuma.
Good morning once again. Let me adjust this a little bit. Thank you so much for those questions. And I'll start with the questions raised by, or concerns raised by Mr. Cornelius. And the first concern that you're raising is on ghost students, where someone will log into the class and then they are nowhere to be seen. Yet the system is showing that they are in class. And in terms of attendance, of course, they are going to meet the attendance threshold. And of course, this is a challenge that we have to grapple with. But there is also a way in which we can still address the concern. I'd take us back to the normal physical classes, where you can still have a student attending physically, but their minds are very far away from the class. And ideally, what the lecturers in our school would do is to prompt you with a question. So they would see that your mind is not here. They would just ask you a question that will bring you back to class. So even as we move online, we can still adopt the same, so that we can just I don't know whether there's an issue or something. Okay, so that the lecturer could just ask a random question and then pick out on anyone to answer the question. Just ask a question and then pick out on anyone. And of course, this is in line with the school regulations. And what can be done is to try as much as possible to enforce those regulations, so that if we are saying, for example, we have live images and turn on videos as we attend class, then we need to try and ensure that we enforce them, so that someone will not be just joining class and then they are very far away and leaving the lecturer speaking alone. So those are some of the practical things that we can do to ensure that when we have 90 people in class, in an online class, they are actually in that class. And remember, and this goes to my brother again. I'm sorry I didn't get your name. This is not what I'm proposing is not. It's not fully. Of course, we can have a situation where we are fully transitioning to online, but for now, we'll still need to have a hybrid learning, so that we see what works physically, we do it physically. What works online effectively, we do it online, and we do that effectively. And then we also, of course, try and look at the clinical courses, which can be effectively done physically, and see what to do about that. And then the second concern by Mr. Cornelius was on the capacity of the students. Because someone could be coming from a humble background, and they may not be in a position to have these gadgets, even purchase data, and so on and so forth. But it's really a challenge, and it's part of the challenges which are coming with along the online transition. But you realize that there's someone who once said that necessity is the mother of invention. And that applies to the online transitions and even to the problems and the challenges that we are having. And with that, I'll proceed to give 2 recommendations to solve this problem. And the first one is to change the narrative. And I'm glad that we are having these conversations, even in this conference. By the mere fact that we had a conference on digital transitions, it means something good, and it means that we are starting to have this conversation. So let's try as much as we can to change the narrative. And once we change the narrative and show our parents and every other person that these gadgets are necessary for our effective learning, then people will find ways, people will find solutions. Because I remember even when I was joining my first year, of course, you know, times you have financial challenges and so on and so forth. But you realize that parents and every other person would always try their best to ensure that they provide that, provided that it's a regulation, and people have been the narrative has been changed. Then people are going to adopt. And then something else is so what I had said earlier on, and what is in my paper, that we have. We have a dedicated budgetary processes, so that we budget for these changes, so that if it's having a proper ICT infrastructure in schools, then we take a proactive step and budget for them. And remember, in my discussion, the emphasis was on schools. But this is not tied to the schools alone. This also goes to the government, and even when you look at some of the agendas of this the present day government, is leveraging on ICT infrastructure. So Parliament has to really take a proactive step and budget for these all these issues, and ensure that our universities are not financially challenged in terms of implementing these changes. So those are some of the things that we can do. And now on to the third and the last question that you had asked. You were making, I think you say that there is a report, and I'd be glad to have a look at that report. Maybe should you not mind, you can share with me and maybe with us, where it was shown that there is a high level of concentration in physical learning and physical engagements as opposed to online learnings and online engagements. And I to some extent I agree with the report, and to some extent I also disagree with it, because in as far as someone, and this goes, I'll go back to the comment that I'd made earlier on, where you can still have someone present physically, but they are not, their minds are very far away. So for that person, you'd ask them what they learned in that class, or in that their take home in that meeting was, and they have totally nothing to tell you. And someone else has been, maybe was in an online engagement, and they've been concentrating, and they've been able to get what was being said. So again, this goes back to the narratives, and also looking at because some of the things we have at times we have some unforeseeable circumstances, and you realize that we need to be ready, because for this student, when you have two sets of students, one who has been raised and taught in a traditional setup, as I was showing us earlier on, and another student who, throughout their lives, they've been, maybe as young as they've been introduced to electronic materials. So you see, for the latter person, they can effectively concentrate maybe online as compared to the other person. So at times it also depends on the constantly changing circumstances and how we are able to crack it and ensure that whichever method we use, it's effective, and we are able to still get the attention of the student. Because remember, the lecturer will be the lecturer will be competing with a number of things, because if you are not maybe authentic enough, then this student has the possibility of maybe going online, maybe replying an email, chatting on WhatsApp, and so on and so forth. But you realize that also there are some of the actions that we can take, and in addition to what I had said earlier on, we can even have things like say restricted access, so that you have a situation where a student will be using a certain website to log into class. And the case example could be, you can see such restrictions in terms of maybe you are a lecturer here at the Kenya School of Law, and you can at times maybe I don't know whether or not this is the case, but you may not be allowed to access the school system when you are not within the school compound, the school environments. We can also have such a structure where we are going to have restricted access to the platform that we are using to conduct classes, so that if you are in class, you are restricted in terms of what you can access, so that even if you are using maybe a school Wi-Fi, or you are using a school website to attend classes, then probably for the time within which you are in class, you are restricted in terms of what you can access and what you cannot access. And that again boils down to a change of narrative and how ready we are to take such directions. And then now to the last question that was asked, and again, I'm sorry I didn't get your name, but there is a concern that you were raising where you are saying that you registered for an online class, and then you found yourself in a physical class. That's the case? Or the other way around? So you registered for a physical class, and then you found yourself having placed in an online class. I may not be in a good position to address that question. That could be maybe addressed by the school management. And I think there is a comment or something which has been made. I don't know whether that comment has addressed your concern. Okay, then that's it. Maybe to just close on that issue and every other issue, at times you have unforeseeable circumstances where you may think that we've grappled this and everything is now okay. We can now effectively conduct hybrid learning. But 1, 2, 3 months or 1 year down the line, you realize that we were not ready for this. But again, are we ready to constantly change and adapt to the changing circumstances? Is our law able to adapt to to the changing circumstances and be able to address our concerns as we go along? To me, that's the most important thing. So I hope all the concerns have been addressed, unless there is maybe from the people who had asked the questions, unless there is one who is still having a concern. Okay, it seems there is none. Once again, thank you, and have a good day.
Thank you, Nicholas. We can now take responses from Dr. Mutuma. Please unmute him.
Thank you very much, Madam Moderator. I'll be very, very quick in my response. To Cornelius, I think he asked about this challenging terrain that we've been through. He didn't mention specific names, but I could hear things about the Huduma numbers and so forth, and the balance between what the state does in the name of national security as far as privacy citizens' data is concerned and the choice of the citizen. So Cornelius, I think you may want to look at Article 24. It establishes an important test that the state must comply with when balancing privacy and national security. And it uses the words justifiable and reasonable. That there is an ability of limiting the rights that you've spoken about must be satisfied, and it also must be for a justifiable end. I think there's a bit of case law around that, what is reasonable, and it includes elements like proportionality and necessity, both case law within and outside. I've always argued that the ability to take advantage of this rests with us as legal practitioners, and unless we get more of us that are willing to take on the government when it is violating these rights through public interest litigation, they will simply remain rights on paper, and indeed very well enunciated in our constitution. On the question of Matagassia, I think that highlights the problem of this global space, the digital space, and extraterritorial application of the law. So there's a lot that's been done in that area. And what is clear is that we must move away from walled garden strategies, individual governments, when it comes to data. Those walled strategies inside a specific country are becoming more or less obsolete. And more there is a search for cooperation that extends what we call digital jurisdiction and sovereignty. So the new language is of changing the extraterritoriality paradigm from the way we've known it, and creating forums where you have cross-border evidence platforms, including access, discovery, and so forth through regional entities. So I think this is the way forward to try and stay within the borders of national sovereignty in these transnational crimes. And indeed, what you're talking about is a transnational crime of one kind or the other, is becoming more and more challenging. Thank you very much, Madam Maureen. Back to you.
Thank you. We've heard you loud and clear. Thank you for your responses. There was a comment from one of our participants. Perhaps you can give her the microphone.
Thank you so much. Good morning, everyone.
Good morning.
I think I wanted to comment on his question and Senior's question, but I think they have been exhaustively addressed by Dr. Mutuma and Mr. Jeriot. So for now, I think I'll let it slide in the interest of time. Okay. But when we are out there, I think we can exchange some notes with them just to save some time.
Sawa.
Thank you.
Thank you. Thank you for that. We'll now, this brings an end to the morning session. We'll now proceed for our tea break for half an hour. Let's be back promptly. The students will have their tea on the left side of the ramp. I'm sure you all know where that is, and presenters and the lecturers, you'll have your tea up there in the VIP lounge. Let's be back in good time for the next presentations. Thank you. You ready? Camera is not focused. Good afternoon. Glad to see you once again. I can see our presenter needs a minute. We've been talking about the how data is extraterritorial in nature, and thankfully we actually have one of the presenters tackling that issue. I want to invite Mr. Edridge Kaniaro to take us through an analysis on the extraterritoriality of data and the right to forget with a Kenyan perspective. We'll be strict on time in this session, so we're giving presenters at most 25 minutes. When they are over, I will kindly request you to conclude. All right, let's clap and welcome Mr. Kaniaro.
Good afternoon, everyone. Or is it still morning? So I'll be tackling the cross-border data transfer and the right to forget. In the Kenyan perspective, I'll be indulging in the Data Protection Act of 2019, which includes these provisions. Under Section 25 of the Act, it requires data controllers to obtain the subject's consent before transferring their personal data outside Kenya. The Act, the Kenya Data Protection Act, if you've gone through it, you'll realize that majorly or mostly it copy-pastes some of the GDPR provided, some of the sections provided in the GDPR by which is used in the European Union. So I'm going to start with an introduction by explaining the doctrine of extraterritorialism. This extraterritorialism is also known as cross-border data transfer, whereby data is gotten from one jurisdiction and moved to the next jurisdiction. Let's say that you have data which is made in Kenya being transferred to Uganda. Some of this data transferred may be health records, contracts, and such whatnots. So the Data Protection Act provides for rules that may be followed when doing such transfers, and they may be deemed inadequate by some perspective, and some people may argue that they are adequate. But in this document, I'll be arguing the fact that to some extent we've come a long way, whereby we are at least trying to regulate how data is being moved in Kenya to be processed in countries like Britain, US, Russia, and what we can do about it. Under Section 4 of the Kenya Data Protection Act, it states that non-Kenyan entities should comply with the rules set out by the Data Protection Commissioner. These data controllers should stay in line with the guidelines provided by the Commissioner of Data at the moment. Section 48 goes ahead to give a duty to the Data Commissioner to provide and recognize other data protection acts which may bring about and foster better relations when doing cross-border transfer of data. So there are certain challenges that face the enactment of cross-border transfer of data and are provided in the Kenya Data Protection Act. One of the challenges is the limited enforcement scenario. At times, there are breaches that occur when transferring data from one jurisdiction to the next. But what power does the Data Commissioner have in enforcing that the rules and principles which she has set out are followed? You might find that a breach may occur in a country like, I'm going to give an example of Canada or America. What is the jurisdiction of the Kenya Data Commissioner towards that country? In the most recent case, you'll find that during her speech in the Commonwealth Conference, which she had, there are big, quote unquote, big data companies like Google, Facebook, Meta, not Facebook, Meta, think that they are untouched in the Kenyan jurisdiction because they argue that the Kenyan courts have no jurisdiction over them. But in a recent ruling that was delivered by the High Court, you can actually sue companies such as Meta for if they infringe and break these principles set out by the data commissioner. Another scenario is the lack of harmonization of these rules. You might find that a country like South Korea, their data protection principles may differ from what we have in the Kenyan scenario. Such a challenge may bring about a lack of concession in agreeing that in South Korea, we might be okay if certain data is transferred without the consent of the parties. But here in Kenya, the Data Protection Act provides that the consent of the parties has to be gotten. So for your data before it's transferred to another country, you will have to sign a user agreement that gives that data controller permission to take your data from point A to point B. The third challenge, there is unclear. The laws at times, since the Data Protection Act does not specifically and explicitly state that 1, 2, 3 should be done when transferring data to another country. This is given to the discretion of the data commissioner. The data commissioner is given the power to make regulations. She's given the power to determine what kind of rules shall be followed when transferring data, which at times may bring some type of differences, and there might be interests by some players. There are insufficient penalty scenarios by breach, when you breach certain data rules. When you read the Data Protection Act, the miscellaneous section, the penalties enacted, they are quite, I might argue, minimal, because I've seen the highest fine that you might be charged for not following the act and procedure specifically to the letter is probably $1 million. But I welcome other stipulations if there are. So what recommendations what other recommendations can be incorporated in the act? One, there are adequacy determinations. Adequacy determinations are permits, quote unquote, that the data commissioner can give to other countries so that they can transfer data from one country to the next. An example of a Kenyan scenario where an adequacy determination is given, in 2018, the Kenyan government and the USA entered into a concession that allowed data to be transferred from Kenya to the US so that they can bring about the fight to terror. They can bring down the terror organizations. Number two is binding corporate rules. These are rules that are laid down within an organization. An organization such as Safaricom can have rules and regulations on how certain data shall be collected. There was an argument where Safaricom gave out user data to these bank lending apps without giving a notification to the users of the lines that this app, once you register to an app, let's say like Zenka, your data is transferred is shared from M-Pesa to other banks. From other banks, the data is given to the lending app. The user was not adequately informed, which brought about a lot of friction with the communications authority. There are standard contractual clauses. This is a contract whereby it can be entered between data controller and the data commissioners, whereby it says that this contract stipulates I will collect this kind of data for these purposes for this period of time. Once this period of time expires, the data controller is required to delete that information and inform the data commissioner. The fourth recommendation will be data localization. Data localization is whereby an organization is required to store data collected for Kenyans in Kenya. This has been a very contentious matter whereby organizations that are located in other countries and startups to be in particular may argue that this will bring down their eligibility to the international community, whereby if data is only stored that is collected for Kenya, is only stored in Kenya, their sponsors, quote unquote, may not be able to get that data and produce better products for the users. There are data cross-border data transfer agreements. These are agreements that are entered between a country such as Kenya and another country. An example of a cross-data agreement is that one I've given for between Kenya and the USA. An international agreement was one. An example of another international agreement that has been in place is between the European Union and America, whereby they agreed that certain data by the users can be transferred without necessarily looking and indulging the data commissioners of their respective countries. Moving forward, I will discuss the next issue in my article, which is the right to be forgotten. The right to be forgotten is a legal principle that provides individuals can request the data controllers to erase the data which is no longer in use. The basis of the doctrine was first used in the court of Justice of the European Union, Google Spain SL versus Agencia, whereby Ms. Gonzalez had requested the company, which is Google, to delete data which was already in the internet of her about her case, which was already concluded. She argued that even though the data is such as case proceedings are deemed to be public knowledge, the details contained in the case law which was posted by Google were misleading. This was incorporated in Article 17 of the GDPR, and Kenya has borrowed some of the principles by requiring that individuals can request the data commissioner to erase the data under Article 38. Yes. In the digital age, there is a quote that says the internet never forgets. If you post a video today, after 10 years, you'll still find it there. This right provides that you, as a user or as a consumer of the internet, can pose to the data controller in these companies for them to delete that information by writing. That is one of the ways. The Kenya Data Protection Act 2019, in conjunction to the Access to Information Act of 2016, it requires the right to be forgotten in a limited way, but only in public records. But there are loopholes that lead to the promotion that can hinder the promotion of this right, such as incomplete or inaccurate data, that this data can be deemed as public interest even though it is not posted for the good of the public. The data controllers can argue that this data is still in our site because of legal obligations, such as copyright issues and whatnot. There are some data controllers who argue that they have technical limitations. These technical limitations can be the lack of ability to comb through their old data and erase the specifics that you've required of them. The lack of systems of erasure. This can be especially an hindrance to SMEs that are upcoming. In organizations, there is a budget for every activity that is being done. You'll find that some organizations will give very little or no budget to their offices of data protectioners. You'll find that even some organizations do not have such persons working for them. This is a limitation to you as a person when it comes to data that you've given unto them for their use now and in the next future. Some other reason and loophole that may infringe the right to be forgotten is when cross-border data transfer occurs. Some organizations will argue that this data is no longer in servers in Kenya, it is now in Finland, for instance. There are others, when you reach out to Finland, it will say, no, we don't have the data here, we've sent it to another server. Now, in that process of push and pull, some people will get tired and you'll be like, okay, you can still have my data, but I want it taken down, but the organizations will say, no, we don't have it in this server right now. The right to be forgotten is actually very, very crucial when promoting the right to privacy. When you come to determining and explaining the right to privacy in the digital age, it might be very, how can I put it? It might be very inaccurate per se. When this doctrine, the right to privacy, was being conned, we used to say that you cannot enter my place without my permission, such and whatnot. But in the digital age, the right to privacy is seen to be deemed and actually forgotten to some extent. Let's take, for instance, the question of artificial intelligence, which has become a bug, quote unquote, in the recent ages, whereby in the recent scenario, I'll take the case of Obama, there are pictures of Obama and Angelina Merkel circulating around, of them hanging out in the beach, of them running in water. But those pictures were not taken, they do not exist actually. They were generated by AI. But what can you do to know the difference between a picture that is taken in real and one that is generated in the AI? That is an infringement to their privacy to some extent. Now, to counter such infringements, people have advised that maybe AI needs to be shut down, but there are others who are like, if you need to know whether a product has been produced by AI, you need to look at the metadata. The metadata of an object you cannot lie, you cannot configure your own metadata. If you've taken a picture here, by the same use of AI, you can still tell when the picture was taken and who took the picture by using the metadata itself. So moving forward, the right to erasure or the right to be forgotten has been given some exceptions. There are exceptions under Section 39 that the Kenya Data Protection Act provides, that data can, yes, you want your data to be erased, but under these circumstances, data cannot be erased. When that data is necessary to exercise the freedom of expression and information, when that data is necessary for compliance of legal obligations, such as contracts, such documents, when that data is to be carried out to perform public interest documentations. These may be pictures taken of public officials or public heads. Yes, you as a public head, you may want a photo to be taken down. Let's say a photo which was taken during a national holiday. You may want it taken down, but under this Section 39, that may not happen. They might argue that it is to the best interest of the public to see that you are there at that point. There might be data necessary for archiving purposes, such as scientific, historical, and research purposes and statistical purposes. Such data cannot be taken down. Although these exceptions are given and provided in Section 39 of the Act, they are subject to exemptions. There are exemptions such as, even though, Yes, for conditions of exceptions, there may be one, necessity. Is there any other way? Is it really necessary for the data to be deleted? No. If no, why? Necessity. This may come into play when the data controller argues that this data once deleted, there might be no other way in which it can be gotten and be used in future purposes. There is proportionality. Do the benefits outweigh the negatives that the data which has been posted provides? Is the data the data is posted, is it more positive? Is it impacting people positively or negatively? If the positives outweigh the negatives, the data will still be retained by the data controller. There are safeguards. In a recent documentation released by the Data Commissioner, she has provided certain safeguards that must be followed to ensure that data is protected and can be transferred and can be stored. The safeguards may actually infringe some of your rights, but the data controller has to write to the data commissioner to show that I've put safeguards 1, 2, 3, so this data of the person is not lost and cannot be infringed. There's transparency. The data controller should provide clear and concise information of how they intend to use the data in question. This will provide a trust built between a data provider, you as a person, as a data subject, with the data controller, so whereby you know if this information is being collected, it's going to be used to serve the following purpose, e.g., it is going to be used for medical reasons, or it's going to be used to enhance scientific research. If the data controller can be held accountable, they may not be required to delete the data by being held accountable in this sense that they have given safeguards, they have rules, they have procedures if data breaches occur. If these are satisfied, the data controller may not be required to delete the data. And that is the end of my presentation on the paper. For you to get more or run more, the article will be released soon. I've expounded due to the limitation of time. I'll just present on that at this point in moment. Thank you.
Thank you, Mr. Kaneru. You have really stuck to the time. I really appreciate that. We can reserve the questions relating to his paper. Right now, we want to proceed to the next presentation by Mr. Agira, who is online. So give us a moment for the transition to online. Yes, you may speak, Mr. Agira. Please unmute from your end.
All right, I think can now be heard. Give me like 2 minutes to set up. 2 minutes.
All right, we can hear you perfectly well. You may proceed as soon as you're ready.
All right, in 2 minutes. Am I able to share my screen?
Sorry, you're not able to share from your end, but we can hear you perfectly, so you may proceed with your presentation.
All right, my name is Keniz Agira. I was actually looking forward. I thought I'll be presenting around 3, but it's good I'm here. From the program, I see it's duly indicated that I need to present something on the digital rights and internet governance. And Maureen, if it's okay, the presentation where my paper is basically on electronic evidence. Am I okay to do that?
You may present your presentation according to your PowerPoint presentations. I believe it's on electronic evidence.
Yes.
Please proceed. We have it from our end, and we will be sharing also with the online guests as you proceed.
Okay, sure. All right.
All right. Are you, please unmute from your end. We can't hear you.
Oh, thank you.
You can start once more.
Yes, I began by saying, first of all, by affirming that the online classes are working, just from the other discussion I was getting for the presenter, that yes, the online classes are working. I'm currently a student taking postgraduate diploma at Kenya School of Law, and I'm able to attend those classes even from outside the country. That is number one. Then number two, for the discussion today, my paper is basically on the electronic evidence management. How is this? How is the electronic justice really working? And there right away, I happen to be chairman Kenya Cybersecurity and Forensics Association. That brings together lawyers, brings together the law enforcement guys, and also brings together the ICT, the techies. And I'll go straight away to issue of electronic evidence. Question is, what is this electronic evidence? You normally hear it left, right, and center. People talk of electronic evidence. Some talk of it, as digital and all that. But I would pose a simple question to the rest of the attendees. If, for instance, you come across a case on electronic evidence, how will you handle it? Is this something you will be very comfortable to handle? I don't know your answer, but I know it's problematic as we speak. And I took time to look at the laws we have in Kenya. And I can tell you for sure, nowhere is it even defined what is an electronic evidence. We know the evidence, but electronic, that becomes a problem. Then the other thing, again, when you talk of electronic, the question comes, is everything electronic digital? Or when you talk of digital, is it even electronic in the first place? So in that, and I did my paper, I came across a good definition on electronic evidence done by Stephen Mason. This gentleman defined this electronic evidence as data that is comprises both analog and digital devices. And that is capable of being manipulated, it can be stored, it can be communicated. And then he brought the other aspect to that definition, that it has the potential to make the factual account of either party more probable than it would be without the evidence. Three things, if you look at that definition, comes to our mind. Number one, it doesn't matter whether it's analog or whether it's digital. Anything electronic, basically, it could be, it uses electricity, that's why I say it's electronic. But if anything digital, now it brings the aspect of binary, the zeros and the ones, commonly known as the bytes and all that. And that is the first part of it. Then the second part, computing devices, as it is, they have actually basically in three forms. One, we have the open-ended computer that you all know. The computer you have, the one you see. And then we have these other types of the so-called the communication devices, talk with the routers and all that. Then you have the embedded computing system, where it's a gadget, a microwave, it has a functionality of a computer, specific, and those are just computers and all that. And so, whether it in that format, that is a key element. So all those are sources, basically. And then it also brings the aspect that this can be used, not necessarily in court of law, it can be basically even in a tribunal of some sort, administrative action and all that. So I love that definition, and it settles the problem we have, whether it's digital or analog. In our Evidence Act, nothing is really defined. And to that, my paper dealt with, wait a minute, so what are the characteristics of electronic evidence? I looked at the Evidence Act that you have, and basically, we all know the primary evidence. It's there, look at section 65 of the Evidence Act. It brings the aspect of the primary evidence, which is basically documentary evidence. But moving forward, when you look at electronic, the hallmark features of electronic evidence basically borrow heavily from the documentary evidence. Why do I say that? Right now you're viewing the screen and you're even seeing the presentation. If you look at it, it could be in a Word format, but you and I know when you open this computer, you won't find this document, yet it appears like a document. And with that, so the contrast, what are these contrasts? You look at paper-based documents and electronic documents. And a quick run will show you something. In terms of storage, really, papers are very, 1 GB worth of paper or 1 GB worth of data will really be so much. But compared to electronic, it's basically a small gadget, a flash disk. To make it better, for you to understand that, in my paper, I discussed that, you know what, when, assuming you have A4 paper side by side in open football pitch, something on 200 wide per page, that should give you like a whole 1 GB. Think of that. Then look at the backup of electronic. It's not really a problem. But then with the paper-based document, we know as long as you put your paper in a lock and key, you are good to go. The aspect of copying, this again becomes problematic in electronic. You can have various forms. A very interesting scenario that we now see in our penal code. If you look at section 267, 69, that means that things capable of being stolen, information capable of being stolen. But wait a minute, when you talk of these papers, of course, if I made a copy of this, several copies of this would be like the best evidence rule and all that. And then with the electronic, I'll copy it, take a piece of your music, go away, and still have it here. So it can exist in all versions. And the other thing I would mention, basically the security, of course, electronic has a global parameter. You really have to put so much effort to protect that. And as compared to paper, lock and key, where I lock my cupboard or my office and I go my way. But that is not enough. I look at characteristics, then please, the next line. Having done all that, in my paper, there's something I mentioned about the provenance of electronic evidence, and of course the sources. Sources, I would say, basically, as I mentioned, we could look at it in 3 forms. Source number 1, the open-ended computer that we know, talk of the phones, talk of all that we see, and then of course the communication systems that we now have, the routers and all that. Then you can look at these are those parts of the embedded systems, and that now cuts across. When you come to a CCTV footage, come to a phone, all those aspects, they are all sources of electronic evidence. Then the other bit about the provenance, where the question would be, when did we as a country begin to use electronic evidence? In the room, I know you can trace your journey back, but let me jog your mind. Remember, it's 2007, 2008, haki yetu, chanting the air. Then somewhere in Kisumu, we see there's a footage, a video footage in YouTube about, and it's a case of Republic versus Edward Kirui. So a police officer, in the middle of that demonstration, he lifts his helmet, and then what does he do? Shoot some demonstrators, and he's visually pictured well, doing all that. And then this matter really came to court. Remember the case of Republic versus Edward Kirui, you can check on that. It's even a footage in the YouTube. But when this matter came to court, 2008, that is, the thing was that there was acquittal. And actually the judge in that case said, you know what, even though he was positively identified, but he could not reconcile the fact that the ballistic expert findings which showed that the bullet that was discharged from that gun must have been different. The serial numbers and the bullet were not matching. So as a result, you all know, in a criminal law, there was a benefit of doubt. It goes to the accused. So when this matter came, we now see a series of things happening. I'm talking about when did we begin to use this? Out of 2007, it leads us to something. We now see amendment coming. We are into. Can you please go to the other slide before this? So that, I think it should be the next one. That's the next one. The next one, yes. Where there are the laws, Kindly bring it down a bit. We are in 2009, 2008, and something interesting happened. We begin to see Kenya Information and Communication Amendment Act. There's a slide that has the laws, if you check. That is 2000, we are in 2008. A first amendment is done to one act. You all remember this? The so-called Kenya Information and Communication Amendment Act of 2008, the KICA. And that is the law that again came and amended now the sections we have in the Evidence Act, section 106B. What did it introduce? Initially, there was a section about the wills, but then it introduced section 106B that again now talked of admissible electronic records. That amendment went further to even to introduce an amendment to the penal code that even information capable of being stolen as part of things which are capable of being stolen. Same amendment, it went further now in that Kenya Information and Communication Amendment Act of 2008. So we begin to see various terminologies introduced, unauthorized access, funny terminologies begin to come in. Moving forward, we come to 2010. What do we see? The promulgation of our of the Constitution. Somebody will be asking, how is Constitution related to electronic evidence? I'll tell you. In 2010, part of the definition, look at the interpretation article under Article 260 thereabout, you'll find a document is defined as part of what the paper that you have and all that. And then part B of it defined document as electronic files. That is a very interesting thing because in the Constitution, we now begin to see something interesting about electronic files. But first, moving forward, so from Edward Kirui, we see several developments until now where we are. In the Evidence Act, if you check right now, you'll see something. Section 65, subsection 4 of Evidence Act, has something interesting about the computer printouts. And then it gives you conditions for admissibility. Then you move forward, section 106B of the Evidence Act, now introduce something about admissibility of electronic records. Gives you all the way to section 6, various instances. Then you move forward to section 78A of the Evidence Act. Now brings another very interesting scenario, terminology. It categorically mentions electronic evidence and digital evidence, but first short to define what these are. Now that is the journey that we've had till where we are. Moving forward, the question is, where are we in terms of electronic evidence management? I'll request you to bring the next slide before this. All right. So where are we in terms of electronic evidence? I've just mentioned some laws that you can see in the Constitution of 2010, Section 260B, Kenya Information and Communication Amendment Act of 1998. That was a very interesting bit because it's the section that really dealt with unlicensed use of a telecommunication equipment. Remember, they used it a lot to really mess the bloggers and all that. Then, of course, moving forward, we now have the Computer Misuse and Cybercrimes Act, which was really contested, but right now it's very alive in use. And of course, you have the Evidence Act, Section 65, Section 78A, Section 106B, which I think every legal practitioner needs to be aware of. And then, of course, Penal Code, now that introduces the aspect of information capable of being stolen. Now, a very interesting thing, looking at the case laws, this has happened, but now let's come to the challenge of it. Admissibility of electronic evidence in court. Has it been smooth? Kindly show me the slide before, the slide after this, where the cases are. I think it should be the slide before, sorry. The slide before that, yes, another one. Yes, there we are. I picked a couple of cases just to highlight a few things. Admissibility at play. In 2011, there's a good case about Republic versus Mataguda. When you read the facts of that case, of course, some people went had a good time, and then as usual, things went south, and it ended up the lady, I think, was murdered in that. And this matter comes to court. Imagine they had a raw footage of the whole scene. The investigating officer and all, they did all that they could, and they bring this matter to court. But something happened. If you look at the section conditions mentioned in section 106B, that begins that notwithstanding anything, yes, anything in that act, then it brings various aspects that all these are referred to as computer outputs. So if you look at section 106B, begins with the aspect of the computer output will be things like CCTV, things like the raw footage. We are talking about bringing it in form of a CD. That is a section that basically is normally used. So I could take a picture of something happening, then share it, then put it down in form of a CD, and then the next thing that I see, bring it to court. That is allowed under section 106B. They are referred to as computer outputs. Then another thing happens. What if, in the event that that is brought to court, what are the conditions of admissibility? Allow me just a minute, just a minute. My power was almost going out, the advantages of being away. So what happened in that case? They brought all that they could in a court of law, but unfortunately, there is no accompanying certificate. And what are those conditions that are mentioned in section 106, subsection 2? That number one, it must have come from a computer during ordinary course of the said activity. By the person occupying, by the person who is in charge, the owner of that thing, and then that the computer was working properly. Or if not working properly, that the malfunction ought not to have affected basically the workability of that. I will just put those conditions in brief. What are you talking about? Came from a computer, that computer was working properly by the person who had lawful control over the use of that computer in the ordinary course of the same thing. Those are the conditions. Then it went ahead and under subsection 4, that you know what, if you want to give that as a statement, that you must provide accompanying certificate. In Republic versus Mataguda, I guess they never knew of that certificate. You could be wondering inside there that what is this certificate about? I've even seen it in the first place. I'll tell you, it's not even the Evidence Act. But this gentleman, they didn't have that. And as a result of that, that piece of evidence was not used. Very unfair. Moving forward, another case, we talk of William Udembo Dual versus IBC. In my paper, I've given the facts. If you look at that case, it was an election petition. And in one of the polling stations, as you and I know, in this country, elections are contested. So somebody tried to play fishy. He went and stuck ballot boxes. But then one gentleman captured that scene in a video using his Nokia 7 phone, then came to Nairobi, I think he had an idea about this act, developed that into a CD, and then brought that to court, and went ahead and even sworn a verifying affidavit that, yes, this was my phone, I captured this and that. But you'll be surprised when you read the facts of that case. What was the holding? Court held that the prosecution witness 7 verifying affidavit was not a certificate, and the CD sought to be produced as electronic evidence was admissible. That was not enough. Then moving forward, so what has happened since then? Interestingly, another case that I've cited, this was now at the height of the so-called Shabab guys. You know, in Mombasa, there's a time it was so heated. So there's somebody who took a footage of that, went and picked things from social media, and then they wrote a CD and brought it to court. But from that point, we saw again the court deciding differently. They say, you know what, even though the certificate was not there, yes, that piece of evidence was admissible. And before I mention the other cases, so what am I talking about here in the first place? These conditions are important. But mostly, when the conditions are even met, but without a production of a certificate, it becomes a problem. take me to the next slide before I mention these other cases, where we have county government of Kisumu. The next, second slide after this. Yeah, does it have to be complex? The quick answer is no. Why do I say that? Come to the next slide. They say, I love what has since happened in our country. This was a case that also involved County Assembly of Kisumu, and some people were say they were wrongfully dismissed from their job, and so they went to court and came with great evidence of that. And moving forward, some of those that evidence was relied upon. But then I think Justice Mondi, if I'm not wrong, mentioned something. If you look at the paragraph 68 of this judgment, you can go look at the citation. He said a very interesting thing. He said, Evidence Act does not provide the format the certificate required under subsection 106B. Therefore, should you take, the certificate can therefore take any form, including abandonment in the affidavit of the record. Very interesting thing. In that now gives leeway. You may not know how the certificate looks like, but then whatever you are bringing to court, let it conform to subsection 4. What does it say? 1, tell us what you did. How did you produce that evidence? Number 1. Then what are the gadgets? If you use some gadgets to produce this, what were those gadgets? And so basically, the audit trail should be seen. A third party doing a similar thing should arrive to a similar conclusion as you purport to do. That's what the sections tend to say. With that in mind, ladies and gentlemen, allow me to introduce something here, a certificate requirement. Go to the next section. Yes, if you look, maybe from your end you could make it bigger, but again, if you open the Evidence Act, there's a sample certificate given, and it's basically on the photographic, one of photographic enlargement and all that. But when you look at what I present here, I once did this. I'll give this example. I once appeared in some court in Nyandarua, and in Maua, that is, and it goes to a case about email. Somebody swindled money. Actually, he sent money so that some plot would be bought. Then he needed evidence. So whoever bought the plot would send the receipts. Unfortunately, what he was sending seems to have been forged. Then over time, he came, you know what? That was not my email. And then, so we are involved in this. And the question was, how could we prove that whoever sent that was the same person? So in the process of doing that, because in that line of work, we had to come up with a certificate. So I'm showing you just a sample of that certificate. What is it? It's like the one we have here. What does it say? The sections 106B says it gives the particulars, what was done. And then lastly, it must be signed by a person occupying responsible position, the owner, or the one in charge of the management of that. So this is basically like a sample of that, which says, I can use Agira, an employee of this and that. On that material day, I received instruction from so and so, and these are the things I did, and what are the actions I did. And having done all those actions, then basically what are the findings? As you give the serial number, the make and all that, then because I was doing this in my computer and it was working properly, I started there. Having done that, the matter went on. Now, in your case, can you do that? Remember the case of county government of Kisumu and all that, and county assembly? Yes, you can. What are the key elements about admissibility? Came from a computer, by the person occupying that responsible position, and then the computer was working properly during the said period. And the other thing, that certificate has to be signed by you, so that a third party doing a similar thing would arrive at a similar conclusion. As I wind up, so what is the conclusion here? I would say this is a new area. Right now, we're talking of ChatGPT. The question is, we've seen many things happening, deep fakes and all that. When this matter comes to court, maybe as a result of manipulation, somebody has drawn you as a woman and all that, and maybe some crime is committed. How would you handle it? I think with that, allow me to conclude by making a recommendation that, ladies and gentlemen, time has come as lawyers. We have now to rise up to the occasion. And number one, if need be, my number one recommendation would be that Kenya School of Law introduce these courses, and maybe as a unit to be done, so that as we come out of Kenya School of Law, we are really abreast with the current happening. Then number two, let's now begin to promote a seminal paper, have to have a discussion around the conditions of admissibility of electronic evidence. You and I know they are really shrouded in some sort of mystery. It's not easy to understand them, and even the certificate requirement, it's really not well thought out. So with all this, I beg to end my presentation. Thank you.
Thank you, Mr. Agira, for taking us through the various risks that are associated by relying on electronic evidence, the various vulnerabilities of even hacking, and also for the challenge to the Kenya School of Law to keep with the times and introduce lessons that would prepare advocates on handling credible electronic evidence. I think for everybody who's here and who's online, we are living the reality of what it means to come on board and bring the changes that are being caused by digitization, and you can see the difficulties real time of what that means, and the seamlessness that we really crave cannot happen any sooner. But of course, all actors are doing their very best to be able to adopt with the space of digitization. At this point, I will collect questions for the presenters for the mid-morning. If there are any questions, this is the time we'll take them. Or there is a participant online who has a question. You can allow them to speak. Good afternoon.
Sorry, I was just testing. Now, I have a question. Thank you for the presentation, Mr. Kennis and Mr. Kanyaru. I have one question for each. The first question is for Mr. Kanyaru. The question is, the right to be forgotten, is that right available to a public officer whose statement has been preserved, say on the internet or on the website and concerns the public? Can he or she exercise that right to have the public statement deleted? Then the second question concerns electronic evidence. Where a photo or a message from a phone is printed using a computer. In such case, who is supposed to do a certificate for purposes of admissibility of that evidence? Does one require two certificates? One to confirm that the first computer, that is the phone, was working properly, and number two, also another certificate for the computer that the computer was working properly? Or is it just one certificate at the final output, which is the printout? Thank you.
Thank you, Mr. Kuloba, for your questions. We'll allow now Mr. Kanyaru to give his responses, and then Mr. Kennis will take questions.
Yes, good afternoon once again.
Good afternoon.
On whether public officers can exercise their right to be forgotten, it is a norm that public officers are to be held at a higher threshold than citizens of the Republic. Therefore, their actions and their accounts may not necessarily fall under this right, for they are required to go by their statutory requirements. Here in Kenya, in Chapter 6, they are supposed to abide by Chapter 6. So, public officers are not entitled to the right to be forgotten unless the information they posted is inaccurate or a lie. If it meets that threshold, then they can request for their erasure, only if it is a lie or inaccurate. Yes.
Thank you for that response. We can see the emergence of a new right and also, conceptualization of what the limitations to that right would be. And I hope, Mr. Kanieru, your paper will be encompassing these things that are coming out from plenary. Thank you. Mr. Kenneth, you may proceed to answer your question.
Thank you. Actually, those are the issues that even the police officers right now are grappling with. The issue of how many certificates. Looking at the act as it is and what we've seen happening in the courts. Number one, they say that if you want to give a statement of what you're bringing in court, what should you do? You need to tender a certificate. You must provide a certificate. And what does the certificate do? The certificate should do the following things. Allow me to read that verbatim. It's very interesting what the provisions of that certificates are. That in any proceedings, I'm looking at subsection 4 of section 106B. In any proceedings where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following. 1. A. Identifying the electronic record containing the statement and describing the manner in which it was produced. B. Giving such particulars of any device involved in the production of that electronic record or may be appropriate for the purpose of showing that the electronic record was produced by a computer. C. Dealing with any matters to which condition mentioned in subsection 2 relate and purporting to be signed by a person occupying a responsible position. If that bit is very important, to be signed by the person occupying responsible position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate. Look, the drafters, they do this. Two things come to mind. One, what they want their certificate to do, and in line with the County Assembly of Kisumu ruling, that it's not given, but what it should do, it should really make it easier for the third person, the other person doing this, or the audit trail can be traced. So my answer would be, it may require you to have even 10 certificates. In some instances, it may require 1. Why do I say so? Because take instance of the case we just mentioned here of the election petition we just mentioned, where we realized that that person used his phone. Then upon using his phone, he went to Nairobi, came to Nairobi, developed into a CD. So this phone, why they did not admit that piece of evidence. If you look at the ruling, then that piece of evidence, it never told us the condition of the phone. Was it even working properly? And then what actions did he take to arrive at what he's doing? The key thing is, can a third party doing that thing arrive at a similar conclusion? So that may necessitate having more than one certificate if there are several processes that have undergone. You need to show that. Or having one if it is you who has done that. Many times I would say, most people are not even aware that phones are working properly, even when the computer working properly. So that becomes the dilemma in all this. But yes, the certificate can be 1, can be 2, can be 3. And those are the issues now as legal minds, we now need to come up and show direction. Thank you so much.
Thank you. Thank you for your answer. I believe, Mr. Kuloba, that is sufficient. We have one more question from Mr. Nicholas. Actually, 2. Let's hear from Nicholas. Oh, there are 3 questions now.
Yeah. Thank you so much, Mr. Kanyaru and Agira, for those substantive presentations. And I have only one question to Mr. Agira. And this relates to the admissibility of electronic evidence. And you realize that there has been a controversy in the two provisions, that's sections 78A and 106B, in as far as the admissibility of electronic evidence is concerned. So that, this has been widely written about, and I think what I have in mind is what was written by Dr. Isaac Rutenberg, Stephen Kiptines, and someone else, where they are talking about the controversies between the two sections. And what they are proposing is an amendment of section 106B to feature the provisions of section 78A. So I would like to know maybe what are your general thoughts, because of course the issue that arises is how to prove the authenticity of an electronic document, even as we transact online, and how you are going to ensure that whatever you're presenting in court is authentic enough. So maybe what's your general view on the conflict in the two provisions, and probably what is what do you think we can do about the same?
Thank you. Mr. Agira, please note that question as we pick a second question from the audience. Yes.
Thank you so much. Mine is not a question, but I think I would like to pick your thoughts about electronic evidence. I think that many people are getting away with crime or injustice because of that provision of need to provide a certificate of electronic evidence, and the need to have the device which was used to take evidence to be serviced. I don't know at what intervals, but I know it needs service. If I can give an example, if a crime is happening right outside this room, and I take my phone, or someone takes their phone, and they do that recording, why can't our courts take that as evidence of a crime being committed? Because at the end of it all, I'll bring my recording, and then there'll be questions. The defense will come and they'll say, has this phone or have this camera been serviced? Where is the certificate of electronic evidence? So I don't know your thoughts about that, but my opinion is that I think that is a technicality that maybe that can be dispensed with when you are giving evidence, so that many people do not get away with crime that people have seen and people have recorded, simply because they do not have those two requirements as needed under the electronic evidence. Thank you.
Thank you, Sophie. There are two more questions right there.
My question is on right to be forgotten. And I want to ask if criminals can enjoy this right, and if they do, does that limit the right of another person, right to access information? And my other question is, the right to be forgotten, is it a new right, or it's an element or principle under the right to privacy?
Excellent. Thank you for that question. We shall begin with Mr. Agira online, responding on the three questions, and then we'll conclude with Mr. Kanyaru.
Thank you. I have two questions. Number one, let me begin with what are my thoughts? Where people are getting away with this evidence, can the court just admit what they're given? That really matter. If you look at the county assembly case, I'll request he reads it. the court really said in that case that the conditions are made stringent because of the nature of the electronic evidence. You and I know it's volatile. We live in an age where we talk of the deep fakes. We live in a world where anything, and you see, just a mere putting of data. If you place a data in a document, if you put a full stop or a comma, it simply changes even the metadata of that thing. So at the end of the day, everything can be manipulated. You are not so sure what basically is happening. That's why the conditions are stringent. Let me begin from there. Having said that, I'm looking at section 78A. To me, I don't see much controversy in that. I'm seeing in answer question 2. There's a good I'm actually looking at the section itself, section 78A. To me, I find it very relevant. Why? And it gives a leeway. What is so tight in section 106B is made lighter in section 178A, and I think with good intention. Why do I say so? Under section 106B, it refers to computer outputs. Outputs in this case talk of the CD, the computer itself, talk of the phones, the cameras, all these gadgets, basically general source of electronic evidence that is really captured under that. But when you look at section, I throw something in, look at section 65, subsection 4, where you talk of the microfilms and all that, and then the whole DAB computer printouts. So you would find something, the ATM machine, the emails and all that really fit in that billing. The conditions are the same, computer printouts and computer outputs. But when it comes to section 78A, interestingly, it comes immediately. If you look at Evidence Act, section 76, brings another new concept of teleconference and video thing and all that. Then you come to section 78A. Number one, how do you admit evidence from Facebook, WhatsApp, talk of TikTok and all that? This is a good provision for that. In any legal proceeding, electronic messages and digital materials shall be admissible as evidence. It begins. But then the problem with this, where now I also come to what the first, I didn't get the name right. They said about Rottenberg and they have said there's controversy. It comes by the electronic and digital evidence, and it fails to really give more information about that. To me, I feel that is a bit, there's something that needs to be done. Then, but it goes ahead to cure a problem of these short messages, the so-called Facebook portal, that they shall be admissible. Then it does a very important thing. Look at section 2 of that. They say that court shall not deny admissibility of electronic of evidence under subsection 1 only on the ground that it is not in its original form. To me, I find that very helpful. And then it goes ahead to say, you know what, you could get this evidence, but then what weight do you give it? That in estimating the weight, if any, to be attached to electronic and digital evidence, the following regard shall be to, number one, the reliability of the manner in which that electronic and digital evidence was generated, stored or communicated. Then part B, reliability of the manner in which the integrity of the electronic and digital evidence was maintained. Then number 3, the manner in which the originator, what has originated that originator of that evidence as was identified, and D, any other relevant factor. Guys, how can this be? And then you come to subsection 4 of that, it also gives another leeway, where I now say it's a very important provision. Whatever was produced, whether copy or printout, an extract, or whatever it is, can be used whether in criminal, administrative, disciplinary, and all that. So, in summary, what am I saying? Yes, the conditions are stringent because of the volatility nature of what you're dealing with. So courts can't just accept what you bring. Like during Mandaman, we saw pictures flying from 207 and all that. They can't. They are circumspective about that. So they need that stringent measure, which is a good thing. Then number 2, a lot has to be done. Actually, this is now the time to basically amend or introduce regulations in Evidence Act so that it gives clear guidelines. When you talk admissibility, what are these? And how do concise, because as it is, I submit, there's a lot of confusion that is in there. So yes, there's controversy, there's a lot of confusion, but deeper inside, if you look at it, basically it serves to cure a problem, but much has to be done. Thank you.
Thank you, Mr. Agira. We'll now get to hear from Mr. Kanero.
Yes, I will start by answering the question on whether the right to privacy is a right by itself or a concept under the right. Oh, no, the right to be forgotten is a right by itself or rather a concept under the rights to privacy. One, we need to understand that we are living in a digital age and human rights are evolve. Human rights evolve with the time and space. You can remember back in the 90s, the beginning of the 90s, in the 19s, let me say that the right, it was a right, it was your right for you to own a slave. It was okay, it was cool. But now, in the digital age, we are moving forward. Right now, there are people who argue that the right to internet should be a human right. Why? Because we live in a digital era. So, for the time being, the right to be forgotten may be considered as a pillar to the right to privacy because of the progressive nature of digital technology. But in the coming era and the coming time, the right to be forgotten may come and become a standalone right. Why? Why is the right to be forgotten so important? In that, you as a person should consent what should be posted about you in the internet, what a data controller should take from you, even when answering those forms that when applying for something in Google, or even when those who applied to come here using the link, there is a form you filled. That's right. You can ask the data controller of the school to delete your information after the conference. It's your right. It's supposed to be an absolute right. Now, when it comes to criminals requesting for their data to be deleted, I've said, and it is of importance, that public interests, issues concerning the public and public interests are not subject to erasure. This was also held in the first case that was heard about the right to be forgotten, which was the Google case and Angelino, the one I've posted. In that case, that was one of the major building fundamentals, the right to be forgotten. Yes, you should consent what data should be posted and whether it is relevant. You should be the person to tell the data controller, this data is inaccurate about me and can you please delete it? But when it comes to criminal proceedings and criminals who have been convicted of a certain charge or have been acquitted of a certain charge, remember, cases that have been taken to court are of the public record. And data in the public record cannot be erased, which is provided under Section 38 in the Data Protection Act of cases in which data cannot be erased by the data controller or the data commissioner. I believe that answers the question. Yes.
It does. Thank you, Mr. Kanieru, and thank you also for Mr. Agira for your presentations and for the audience for all the questions that you have raised. They will definitely improve the papers that will be finally submitted for the journal, the Kenya School of Law Journal. Let's appreciate everybody with a clap. All right, at this juncture, we'll break for lunch, and I want to request us to be here promptly at exactly 2:30 or before 2:30 p.m. so that the next presentation starts at 2:30, and at best, we should be done within an hour of the 3 presentations that are remaining. So let's do our best. Everybody, you can see Jacqueline at the registration desk as we exit for your meal cards, and then we meet again at 2:30. Kindly. Enjoy your meal. All right, I believe we are also online. Thank you very much for coming back for the last of the sessions, for powering through. It's not a main feat. So I really appreciate that. At this juncture, we shall have a presentation from Ms. Diana Wanjiru Mwai on the topic on law, ethics, and social media. She'll tell us more about herself and expound on her topic. Karibu, Ms. Mwai.
Good afternoon, everyone. As you've heard, I'm Diana Mwai. I'm an advocate, and this lovely afternoon, I am going to take you through law in the digital space and fundamental rights, a correction on what's on the program. All right, so I believe I won't take too much time because my previous speakers have talked about some of these issues. So I will just go like an overview and rush through. So when we, let's start. So the sub-themes that I'm going to go through is adapting core constitutional values to the needs of the digital space. It's not reflecting there. All right, so let me just continue. So I will be speaking on 4 issues: adapting core constitutional values to the needs of the digital space, the impact of the digital technology on constitutional values and principles, a little bit of digital surveillance and commodification, and human rights, democracy, and the digital age. So as we know, the constitutional values, they are in the Constitution of Kenya, 2010, Article 2. So in this, the Constitution gives us a list of the values that we need to adhere to as Kenyans. So these values will go from human rights, patriotism, participation, inclusiveness, good governance, non-discrimination, etc., etc. So how have we adapted these rights into the digital society? As we know, the digital society is this space that we access when we access the internet, when we log in, when we share information, when we use social media. For one, I feel like social media has been an area which has really it has really enhanced our human rights in the freedom of expression, freedom of assembly, and right to access information, because we see a lot of issues that are addressed in the social media spaces, in blogs, and we've seen governments also answering towards it. There's also the adaptation of the government in transparency. We've seen a lot of ministries have access online. They give us the updates. We're also able to access tenders. We are also able to see, like in the court system, like for example, when the election petition was happening, It was broadcasted. Every Kenyan saw. That's another area that the digital space the constitution has adapted into the digital space. We've also seen integrity in the form that we can now track how governments spend. We can also track budgets, how budgets are being spent in various counties, and also raise issues unto them. We have also seen good governance in establishment of delivering of certain services like e-services, registration of businesses, teams. Those are some of the things that the digital space has opened up to adopting core constitutional values. In terms of equality and discrimination, the government did roll out in 2016. They rolled out the digital literacy program, which was supposed to have every student to have a computer and every teacher, and also the teachers to be taught so that they can be able to deliver well in terms of digital literacy. Maybe the issue would be enforcement of these rollouts. So there's also the National Optic Fiber Backbone, which is to ensure that every person has access to internet. The enforcement still may be a problem because we've seen that in areas that are marginalized or very far away from key cities, they cannot access internet. So in participation, we've seen, I would give an example of Twitter Spaces, where ministries, government organizations, private companies, open spaces where they include people to participate and air out issues affecting them, and etc. So we'll go to now, like I've said, the challenges that are being affected, which I would say that previous speakers have talked about, are privacy issues, security, the digital divide. When we say digital divide, we mean that the gap between people who have digital knowledge is widening, because we see that in people in areas where they can't access internet, they really don't have this knowledge that we have. So when we come to communication, there's a barrier. There's also a challenge in protecting digital rights, especially on the issue of privacy. As we've seen, people actually give out this information without asking. So it's a little bit hard protecting someone who doesn't want to be protected and someone who's ignorant. So there's also the problem of promoting digital literacy, like I've said. And for my remedies, I recommend that on that issue, I recommend that people be really aware of these rights. People need to know and understand that you cannot expect the government to protect you or to come up with laws to protect you without you yourself having some form of knowledge of what your rights are and what your privacy is. So we'll go to the impact of digital technology on constitutional values and principles. So we've had positive impacts, and personally, I think the digital space has really changed the way the government is leading this country in terms of freedom of expression. I see it every day since at times I'm on these platforms, on the blogs, on the social media platforms, and I see issues being raised by people in terms of how their counties are being governed, how maybe a company is how a company is conducting its business in the organization. And once these issues are raised, I tend to see that they are addressed quickly, in a more quicker manner than when we raise it individually, like using maybe like going to their offices, because there was an issue of passports being delayed. The issue was raised in various platforms, and we saw that issue being handled immediately. We've also seen that, say, like a ministry like Kenya Power, we see any people in the past, people used to complain about about power outages, but since the opening and transparency, we see that Kenya Power endeavors to tell you which areas will have a power outage. It helps in planning. And that's another area where it has impacted well. In government accountability, in promoting social activism and civic engagement. This is like the likes of Kituo cha Sheria, the Law Society, the ICJ. We see issues being raised and being addressed, which is a good impact. We've also seen easy access to information and government services. I feel like the fact that when you need something from Huduma Center, you can go into their site and book an appointment instead of lining up and taking your whole day there. So you'll know you need to go there at 2 p.m. and you'll be there and you'll be served, which is increases efficiency. And we have also seen promotion of equality in marginalized communities. So when you go to an area and you take a photo of maybe a bad road, so you can put it in the media and you go like, what is the governor or the area MP doing? What is the government doing to this area? You find that that issue will be addressed, and it's in the motion of promoting government accountability and also promoting equality in those areas, because what we enjoy, whom we are like we are in the cities or where areas where we find resources easily, is enjoyed by other people. In also promotion of equality, we can say introduction of the M-Pesa. A lot of people never used to go to banks because banks was known for people who have money. So now through the access of like a fintech like M-Pesa, people can transact. It reaches beyond areas where banks go, which is also a promotion of equality. Negative impacts. We've seen digital surveillance. That will be my next topic, so I will expound it then. Enrichment of our fundamental human rights. This happens mostly by the government, if not by private contractors. We've seen in times of elections mostly, we've seen the government interfering with how information is shared. There was also the incident where there was a whole blackout, media blackout. Then in the next few minutes, you see the president being sworn in. That's an infringement of the freedom of expression. Transmission of fake news. This is rampant. Bloggers out here just blog anything and people get on it. Their emotions are aired. It causes even issues of violence. Like in the time of these mandamanos that were happening, we could see bloggers blogging issues that were not happening, inciting other things. So these are some of those negative impacts. Cyberbullying, when you maybe post a photo, when you post an opinion, like people will come there and bully you, like remove your personal information from somewhere and come and like expose it, bullying you because of that opinion that you had. Well, we see that you can't really enforce your rights. You can't go to a court of law and say that you are bullied by this person, because probably this person is a ghost, like a ghost, what can I say, user, because they have a pseudonym. It's not their name. Such issues make it so hard for someone to exercise their rights. We see the commodification of data, data mining by various private companies. Like, for instance, when you use your card in a supermarket, you'll start getting promotional messages. When you use your phone to pay, you start getting promotional messages. When probably you access a site online, you access Google, you search for something, then you start getting advertisements that you really don't want to see. So such things are what I would call the impacts or negative impacts. So next we have digital surveillance and commodification. And this topic has been dealt with, I feel, extensively. And for what I would add is the factors that are leading to digital surveillance and commodification. I would say lack of proper regulations, and also lack of digital literacy and ignorance. Now, I would explain this in form of when you enter a building and there's a CCTV camera, you see the building manager should actually say why the CCTV is there. They should follow steps to ensure that you, as the person accessing that building, knows that they have adhered to and that your information won't be shared out there. But this doesn't happen because on several occasions we've seen videos of CCTV being shown. So you wonder why. You wonder if this data processor, the person, the data handler, had permission to share this information. Ignorance on the part of you'd access somewhere, you'd leave all your information at the front desk, not even questioning why you're leaving it, not even questioning how this your information will be, whether it's protected, what happens if that book is stolen, what happens if you forget your ID there, will they keep it safe? And such issues. On regulation implementation, the Data Protection Act has been criticized for being vague. Now, it touches on issues, touches on these and these, but it won't go to the depth of it. So data handlers use those loopholes to use your data in the wrongful way. So what happens when there's that lacuna in law? You see there's a lot of abuse, which can lead now to your data being commodified and third-party users. And this happens by big companies like we've had Google, we've had Amazon. The information that you leave there is shared. And the impact of digital surveillance and commodification, we've had issues of cybersecurity. There's in my practice, I've had companies being hacked, and this is where now you wonder what happens to the data that is there, because the impact is so huge. And in case like a university is hacked, there's an issue of financial data, there's an issue of the students' information, the grades, what happens to it. So like the digital surveillance and commodification, it happens that when your data is commodified, when your data is sold, you do not know what that person will do with your data. Like when your card is hacked. Maybe some of us have experienced this. I have experienced it. I used a card online to purchase something online, but then I see deductions in my account. I call my bank in a panic, but they will say that, but you applied for something, for a trial, for something. You did this for something. You put your card information there. So it's that site that I put my data there did not do what it was supposed to do when it comes to protecting my data. So there is also infringement of privacy rights, infringement of freedom of expression and association when the government surveils its citizens and wants to know what everyone is saying. And if a person says something that is against the government, they now the security people on you, and you'll find that you're told to pull that post down. Why are you told to pull that post down if it is the truth? Like we've had exposés of corruption. We've had exposés of government officials acting like involved in deals that impacted negatively in the counties. We've had issues of favoritism when it comes to tender issuing. We've had issues where even legal officers are aired out because of corruption and dealing and taking bribes from the plaintiffs or the defendants. So some of these, the whistleblowers, when they put this information out there, you see that it comes to a time they delete it. So you know that person has been threatened or their life has been threatened. So they felt that instead of it going negatively for them, they remove this information. So, and infringement of freedom of association. When, say, a civil society says that they want to do like the mandamanos that were happening, but now they plan and they say that we'll have this match on this day because we want to talk about, say, probably the way the judiciary is not, this is an example. We say that we're having a match because we feel like this registry delays the output of our files are getting lost and all that. So maybe if someone in the judiciary wanted to curtail that, they would shut down that site. They would ensure that that site is not visible to people. In that manner, because they are surveilling, they are looking at who is talking ill about the judiciary. So in the same way as the government, they track your information, they track what you're talking, they do track. So this information is even used in companies where you'll get that you're not being hired because someone has seen what you posted. So when it comes to issues like that, surveillance really impacts in the wrongful way. And in the rightful way, we see, say, in curbing crime, I would say that's a positive impact of the surveillance. If this information is used in the right manner, then using digital surveillance would actually benefit the people. Next, we'll talk about human rights, democracy, and the digital age. I think we all know the definition of human rights. And these are the rights that are inherent to all human beings, regardless of their race, gender, sex, ethnicity. And they would include things like right to life, equality, freedom from discrimination, right to justice, freedom of association, freedom of media, access to information. And I think I've covered a little bit of that in my earlier presentation. And Well, when it comes to democracy, democracy is the will of the people. What do the people want? So we've seen that when it comes to our democracy, the most, okay, I would say the government is called when it comes to democracy. When it comes to infringing the will of the people, the government has been faulted in that area, which in issues, say now, in freedom of expression, you would find that you are not free to say what is there, what is happening, because in retrospect, you fear that something bad will happen to you. There's also when you try, because we use the digital space in spreading information for the media, for bloggers, for people who use their social platforms to say social activism. These are the areas where we create awareness. So in times we've seen mostly when there's infringement of these human rights by the government, and also infringement of our democracy happens when elections are due. When that person who wants to get in there will push, will employ people, will buy data to know who and who will vote for me, what are they saying, the information, like using algorithms to only show you what you need to see. Like, it's not a depreciation of what is out there. In the election periods, we also see that areas where there is fracas, there is a media blackout. You can see. So you in this region will just assume that the elections went well. So such things are an infringement to our democratic rights. Democratic rights are also infringed in when other governments try to use information that they are getting from the digital space to influence how our government is working. That's an infringement of all the international space into our rights. We can also say that, just a minute. So also the widespread use of the digital space and the digital platforms, as much as they have enabled governments, they have enabled the civil society to disseminate information and hold governments accountable. We are seeing threats in terms of like digital terrorism, where now, since it's open, it's global, we see interference. We see you may be searching for something online, then you're taken to another space where you did not intend, then you're influenced in a manner that is not even morally upright. But I would say that even opening up of our space to the international community has its benefit also in our democratic rights. It has its benefits because now the current or the governments that are ruling us cannot rule arbitrarily. We see, like, say, the UN, they would see how maybe Kenya is performing, and they would comment on that, pushing a conversation from the local people, showing Kenyans that we can see what is happening, and any government that wants to rule arbitrarily is actually kept in check, which also it goes on to show that the will of the people is upheld. So the impacts of the digital space to democracy and human rights. We've been more aware of our rights. In fact, I think the awareness is created maybe in access to justice. I've seen that people are more aware that you can sue someone for infringing on your rights. You can also call out someone for infringing on your rights. You can also call out the government for issues, maybe transparency, corruption, there's civil activism, there's social justice where we've found people talking about their communities, talking about how they're being affected by issues, maybe bad roads, water, bad governance. We've seen the access to information, which is quick. I would also commend in our area, the judiciary. Since the online courts, since the e-filing, things have been seamless in practice per se. And which also shows you, doesn't matter how young you are in practice, you can navigate through easily. We've seen even a more practice of our democratic rights, like speaking out on issues affecting you, affecting the community. And there's also much political awareness. I would say because younger people are more involved these days in what politics are, what voting is, all that and all that. My recommendations as I clear off, I would recommend more digital literacy, embracement of the digital space. And our profession is one that really needs to embrace this space and to know that it goes beyond Zoom, it goes beyond virtual courts, it goes to issues, legal tech, it goes to data protection laws, it goes to cybersecurity law. So these areas that are emerging should actually be taught in our schools. We need more cooperation from key players, cooperation in including us, not only the people who are up there, but including everyone in decision making, in coming up with these laws. And there's also better legislation and regulation and implementation. There is no need to have very many laws that have not been implemented and enforced. There is also more knowledge on digital law within our space. There is integration of digital law in legal institutions, conducting more training like this, and and amongst others what my previous speakers have said. So thank you so much for your time. And finish.
Thank you very much, Ms. Diana Mwai, for your remarks on sub-theme 3. And I note that the approach was that you covered every subtopic under sub-theme 3. So that's commendable. Thank you. Next, we will have the presentation by Mr. Arnold Ochieng Oginga as he takes us through demystifying access to the internet as a human right. Posing the question, is access to the internet a right or a luxury? Let's clap for him.
Good afternoon, ladies and gentlemen. Okay, by way of introduction, my name is Arnold Ochieng Oginga. Today I'm wearing two hats, one from Ochieng Oginga and Company Advocates. Then the other one is from ID8 Tech Policy Africa, where we deal with a lot of tech law litigation. Currently, we are involved in a number of tech law litigation in Kenya. I think it's the first, we are the first proactive country to venture into tech law litigation. In fact, my topic is inspired by one of the ongoing cases, which that is the Kituo cha Sheria case, in which they're seeking to have access to the internet declared as a fundamental right in Kenya. Then secondly, we have issues pertaining to social media responsibility and accountability by content posted by third parties. It's ongoing litigation. Then we also have a fairly recent case on the use of AI and machine learning and algorithms, on the use of geodata and the implication on the right to privacy. So ID8 Tech Policy Africa is involved in these cases as an amicus. Now, permit me to go to my presentation, and perhaps by a show of hands, how many of you believe that the right to access the internet, that believe that access to the internet is a luxury? By show of hand, that it is a fundamental right? Oh, okay. That's interesting. So basically, my paper is structured in 4 key areas: the introduction and background, then the international community response to that question. Again, I'll look at also the judicial response, both from the national, regional, and international courts, how they've addressed that issue. Then I'll look at the inadequacies in terms of the judicial pronouncements and the response by the international community. And finally, I'll delve into the conclusions and recommendations. I'll focus so much on case law and pronounced judicial expositions, because to me, I believe as a human rights practitioner, you only feel the impact of a human rights violation. It becomes more apparent if you read the case law. Otherwise, if you don't consider the cases or decided judicial pronouncements, it remains more elusive, it remains more theoretical and hypothetical, so that you have to look at it through the lens of case law in order to appreciate how the judges have addressed the issue. Now, the good thing, most of the speakers have hinted to this discourse. Most of the speakers have addressed the aspect of human rights, different violations. So I wouldn't focus or delve on that so much, so that in my paper, again, the slides should be available for circulation. Don't strain too much in terms of picking out the citations or writing. So that in my introduction, the paper adopts a broad definition of human rights as a fundamental basic minimum standard of treatment and recognition of treatment in various spheres of life, socially and politically. So that with such a definition, it is imperative to accord recognition and legislation on emerging human rights in the 21st century, which has seen the growth and development of different technologies such as AI, machine learning, the metaverse, and all such other emerging human rights. So that, again, looking at the concept of human rights generally, one argument has been posed that there are as many theories of rights as there are rights theories. So that now, again, my previous speaker spoke about the right to be forgotten. And an interesting question was posed: is it a right or is it a principle? Yeah. So these are some of the other emerging issues. So that, again, at the end of this paper, somebody might ask, where should we begin? Should we go straight to technology, or should we start with the premise of access to the internet in itself? Yeah. Again, when you talk about technology, so what is the nexus with the electricity, for example? Should we have a right to electricity? Should we have a right to electricity as a fundamental right? Yes. Exactly. I love the discourse because we are in the same state of mind actually. So it gives us that perception, something to ponder about. Because if you start talking about internet, what else will you want? Do you want, even if we go back to access to the internet, now other related questions will emerge. Do you want access to 3G internet, access to 4G internet, access to 5G internet? Again, in terms of technology, yeah, which technology do we want? So that these are some of the things I'm also pondering about, in as much as I'm arguing about the right access to the internet as a fundamental right, but we'll get to that. Now, again, the other issue that my paper covers is in terms of how do we address emerging human rights. It is a wide scope, and then bearing in mind that human rights are not static, they keep on evolving and they grow with us. Now we have new categories of rights, sexual and gender minorities, topics that for a long time the international and national communities have shied away from. So that again, even in terms of the historical development of rights, if you look at, for example, Kenya, at some point we had women-to-women marriages, female genital mutilation, circumcision, all these other practices. But over time, some have been eroded, some have been criminalized, so that you see that is a process, the way rights keep on mutating. And that is a discourse that we'll get into in another forum. Now, permit me now to go to the question on the international response on the aspect of access to the internet. First, I go back to the first international recognition by the international bodies, and this is found at the United Nations level in the 32nd session. This was in 2016, when the UN adopted the resolution on the promotion, protection, and enjoyment of human rights on the internet. Now, in that regard, you'll get this in my paper, in my detailed paper, but just to highlight is that the United Nations Human Rights Council noted the importance of building confidence and trust in the internet, not least with regard to freedoms of expression, privacy, and other human rights, so that the potential of the internet as an enabler for development and innovation can be realized with full cooperation between government, civil society, and private sector, and the community and academics in general. To that extent, I have identified the inadequacies in that resolution. First, it is soft law, as you know, so that there is no obligation on the states to be bound by it. Then secondly, it bungles up, it treats the access to the internet as a complementary right that supplements other rights, so that it does not single out the access to the internet as a standalone right. And then the resolution largely is pegged on Article 19 of UDA, Universal Declaration of Human Rights, for human rights practitioners who are familiar with it. Article 19 simply speaks of the freedom of opinion and expression, so that to the UN as an international institution, the right access to the internet is just but a sub-right under the freedom of expression and opinion. Now, in terms of judicial response, as I had mentioned, in Kenya, as they say, charity begins at home. So my first example is in Kenya. Currently, we have pending litigation in Kituo cha Sheria. You'll find the citation. For IDET, we already filed our amicus brief. Yeah, and one of the questions the court will have to determine is whether the right access to the internet is a right, is a fundamental right, yeah, that ought to be read into various other provisions in the Constitution. Again, this petition comes against the background of the ongoing digitization process, so that a lot of things are happening in terms of digitization, and the government taking almost all its services to e-service, e-portal, yeah, so that it raises a lot of questions in terms of digital literacy, accessibility, affordability, all those concerns. So these are some of the issues that the Kenyan court will have to address. My second example is the Supreme Court of Costa Rica, which addressed the question of access to the internet. It's a lengthy quotation, but the effect is that a restriction on internet access could affect the right to freedom of expression guaranteed under Article 13 of the American Convention, so that the Supreme Court of Costa Rica equally adopted the interpretation as afforded by the UN resolution. Now, again, the other example I pick is in India, that is in the Supreme Court of India, Anuradha Bhasin versus Union of India, whereby the court gives an exposition on the nexus between the law and technology. I've picked out the relevant excerpt. You'll find it in my slides and the final paper. So that, again, this was an interesting case because the court ideally interpreted the right, access to the internet as a right that is closely connected to, as a tool for trade and commerce. Now, ironically in that case, the court did not pronounce itself on the aspect whether access to the internet is a fundamental right. In fact, at paragraph 28, the court pointed out that none of the councils have argued for declaring the right to access the internet as a fundamental right, and therefore we are not expressing any view on the same. I'll get back to that, the import of that proposition. Yeah. So again, in another interesting Indian decision, here, this is interesting and so relevant, and it ties down to the paper submitted by my colleague Nicholas on the right to education. So that in this case, the school in question and the state had imposed a ban on students having tablets in school. So that the petitioners argued they were entitled to have the tablet or the gadgets in school because it enables them access materials, educative materials and all. And surprisingly, the court agreed with the petitioners. And in fact, the court said the right to have access to the internet becomes the part of the right to education as well as the right to privacy under Article 21 of the Constitution of India. The total restriction on its use and the direction to surrender it during the study hours is absolutely unwarranted. When the Human Rights Council of the UN have found that right of access to internet is a fundamental freedom and a tool to ensure right to education, a rule of instruction which impairs the said right of the students cannot be permitted to stand in the eye of the law. At the regional level, we have the decision, this is the Community Court of West Africa, COMESA, whereby most of you can recall when Togo had the protests, when the parliament tried to amend the age limit for the president. Yeah, so that a case was launched before the Community Court of West Africa, where they challenged the action by the Togolese government of shutting down the internet as a result of the protests and online instigations. And in fact, the ECOWAS court in fact held that access to the internet is not stricto sensu a fundamental right, but since internet service provides a platform to enhance the exercise of freedom of expression, it then becomes a derivative right that is a component to the exercise of the right to freedom of expression. It is a vehicle that provides a platform that will enhance the enjoyment of the right to freedom of expression. Right to the internet access is closely linked. Remember the language. The court is saying right to internet access. I'll come back to that again. Yeah, it's closely linked to the right to freedom of speech, which can be seen. So in essence, the court agreed that the internet shutdown by the Togolese government was a violation of the right to freedom of expression. Now, finally, we have at the international regional level, we have the European Court of Human Rights. This was the decision in Turkey, Cengiz and others versus Turkey, in which the Turkish government had blocked access to certain YouTube channels being run by the petitioners, and the petitioner challenged the same on the basis that it was unconstitutional and a limitation to their rights. And the court, the European Court of Human Rights actually partially agreed with the petitioners and held that indeed the internet shutdown was a violation, and the court laid emphasis on the aspect of on the rights in terms of its accessibility and its capacity to store and communicate vast amounts of data. In fact, this is a good decision in terms of looking at the legality and the court's pronouncement on internet platforms such as YouTube. Now, in my exposition, when I analyze the court's decision, now first, we see that the courts are willing to intervene in terms of internet shutdowns, any interferences with the internet. Now, secondly, I feel there is a paradox and an irony, so that even the language by the court says right to the internet. Yeah, it already considers it as a right by implication. But more importantly, where there have been shutdowns on the internet or interferences, the courts have applied the standards for limitation of fundamental rights and freedoms. So that the courts have adopted that approach in terms of looking at the legitimacy. Is it founded in law? What is the proportionality test? All these substances and principles. So that in essence, the courts have fallen short of recognizing and making that pronouncement that access to the internet is a fundamental right. So the irony comes in when the court again applies those standards pertaining to limitation of fundamental rights and freedoms to examine cases whereby there are allegations of infringement of fundamental rights and freedoms. Now, there is the other school of thought, the other bunch which said the internet, access to the internet is a luxury. So that some have argued that there is a high bar. This is one scholar, Vince Cerf, who says there is a high bar for something to be considered a human right. Loosely put, it must be among the things we as humans need to live healthy, meaningful lives, like freedom from torture or freedom from conscience. It is a mistake to place any particular technology in the exalted category, since over time we will end up valuing the wrong things. Again, the other school of thought have suggested that our inability to predict technological developments and the role these developments will play with respect to human rights should lead us to be particularly cautious about immortalizing any particular kind of technology in international law. Again, that recognizing a new right in the internet could lead to calls for rights in other specific technologies that might dilute the protections from freedom of expressions in general. Now, to counter this, you will note that as we speak today, the internet remains a fundamental enabler to several activities. Technology itself is a life changer in hospitals, cancer screening, medical, emergency treatment, all these things. So that one might argue that their assumption is wrong in that they completely disregard access to the internet and the growth of technology. Now, secondly, again, one might argue that the law cannot predict emerging technologies, but the law will definitely have to play a regulatory role so that the recognition of access to the internet will not per se limit the imposition or formulation of laws to govern emerging technologies. Now, despite the foregoing, I conclude that the study is not conclusive, and I call for further research on a shift towards the recognition of access to the internet as a fundamental right and freedom, and the nexus between access to the internet and other emerging technologies. Now, in my paper, as a human rights practitioner, I call for a human rights-based approach, which in essence turns social work's response to the individual human need to a more expansive view that the resources necessary for survival and the development of human potential should be available to all as a rights-based upon our common humanity. In that regard, therefore, my paper argues that access to the internet is not a luxury, but a fundamental right and freedom. Thank you. I hope I've convinced the other side.
Hopefully, we have people who have been convinced to actually explore that area of research, put in more work into, access to the internet as a right. Then we have more voices from academics, meaning it will find its way sooner than later in the judicial space. Thank you, Mr. Oginga. We will now proceed to our final presenter, Mr. Caleb Boisiku. Let's clap for him as he comes to the podium.
Good afternoon. Good afternoon once again. My name is Caleb Weisiko Keraka. I am a trainee lawyer at a law firm known as Anjawala & Kana, where I'm doing my traineeship. I am also a student at Kenya School of Law, where I serve in the Student Governing Council as the welfare chairperson and Class F representative. It's an honor this afternoon to present to you a paper that I did titled The Intersection of Digital Technology, Fundamental Human Rights, Constitutional Values and Principles in the Digital Space. So basically, this paper focuses on examining the interactions and the impact which digital technology has had on constitutional values and principles, and also human rights. Just a brief outline of what I'm going to cover. I will focus on just highlighting briefly on the impact that digital technologies have had on human rights and values and principles. Then I will point out specifically some of the fundamental human rights that I feel are at risk at the face of the digital development in Kenya's digital space. Then I will also point out a few of the constitutional values and principles. Fourthly, I will suggest some of the ways which I think would be very, very useful to mitigate some of these risks posed by digital technologies. There are also gaps and limitations in the current regulatory system that I feel should be addressed, and I will highlight a few. Then I will also point out on the opportunities that are available for policymakers, legislators, and various stakeholders to advance and enhance human rights and constitutional values and principles in this digital space. Then I'll give you my recommendations. So just a brief background, there has been a very big revolution in the digital space, especially in Kenya, because we are seeing communication, access to information, ways of conducting business, and issues around security, accessing to government services. All these things are being revolutionized because of the developments in the digital space. And this has had a very big impact because of the new changes we are seeing in various innovations and various platforms that are coming up. Talk about social media, talk about the internet, e-learning systems, e-books, e-libraries, and various platforms to access electronic learning, digital identity systems, and I'll touch on some of these things, online commerce platforms, issues around artificial intelligence, financial technology, and greatly, which has been spoken about by many of the presenters yesterday and today, is the e-government services. And you'll notice that the government is very, very, keen and concerned to ensure that there is a development and an advancement towards the digital spaces. And I will just fish out the Kenya Digital Master Plan 2022-2023, which points out 4 key pillars: digital infrastructure, secondly, digital government services, product and data management. The third pillar in the Kenya Digital Master Plan 2022-2023 is on digital skills and also digital innovation, enterprise, and digital business. So this actually points out a deliberate effort by the government to ensure that things are moving digital. Actually, 80% of the government services have been digitized. And there has been various plans, including policies, including the Vision 2030, which are very categorical on improving the digital pillar. And you would be curious to ask, in as much as there are positive impacts of digital technologies, especially to advancing human rights and constitutional values and principles, there are equally on the extreme various negative effects. And in this case, let me just single out some of the human rights which I consider to be at risk. This is not an exhaustive list, and you would notice that the previous speakers have touched on some of these human rights that are at risk. So think of the right to privacy, which usually when we speak about digital rights, it appears to be the main one. Since yesterday, we've had conversations around data protection and the right to privacy. So Article 31 is very fundamental, and it raises questions about collection, storage, and use of personal data. I think of the Nubian case, where biometric data that was being collected, including GPS coordinates and various fingerprints, and generally the biometric data that was being required, it was considered in that case to be an infringement to personal, sensitive, and intrusive data that would, breach the fundamental right of the right to privacy. When we also log into these e-commerce platforms, people give out their personal information, their name, their address, their phone numbers, their details about their financial status. Some would even go to the extent of giving medical records. This raises issues about one's right to privacy. We've had conversations about surveillance and communication, or surveillance of communications, and the government has even gotten into a point of censorship and monitoring some of the communications which individuals make in some of these social media platforms and digital platforms. So this right is at risk, actually, at the face of this critical advancement. The issue of commodification of data. Recently, there has been a development on the Hustler Fund, and Kenyans on social media have actually dubbed the Hustler Fund to be a data mining spree, where users give their personal data without consent as they seek these loan applications. So personal information is being shared here, and people are curious. It could be sold for money without their knowledge. So commodification of data, and where personal data is being treated, as commodities, as goods and for services. So this right is at risk, and we've had deeper conversations on that. I'd not want to belabor it. Article 33 on freedom of expression. In as much as digital technologies have advanced this fundamental right, there are issues about hate speech and online harassment and intimidation. People who tend to be expressing controversial opinions are subjected to harassment, threats, and even various kinds of intimidation and abuse. So the right to express, in as much as it's advanced by digital technologies, you will notice it is at risk because consider during the era of COVID-19, a lot of false information and misinformation in this case happened at the exercise of this right. So you would question whether digital technologies should be limited to an extent that they do not infringe on some of these fundamental rights, and we'll get to that discussion. Article 35 on access to information. I'll just point out the aspect of digital exclusion, and digital exclusion in the case of marginalized communities, vulnerable groups. And in the morning, we got a hint of premium accounts where you have to pay to access particular kind of information, where you have to subscribe to access particular kind of information. So how about communities or individuals who do not have the capacity to access that kind of information? You notice there is a limit there. Also think of the people living with disabilities. How does the government ensure that some of these platforms in the e-government sector, e-government services, are accessible to people who are blind, to people who can't hear, to people who can't, access physically some of these services, let's say in the Huduma Center, in as much as they are decentralized. There is also the concept of misleading and false information. People can access false and misleading information. I would also want to point out the article number 27 on equality and freedom from discrimination. The bigger problem posed by digital technologies is that there is the risk of advancing further the existing stereotypes and discriminations, because some of these artificial intelligence platforms and digital platforms are basically, they give responses and data based on information that is fed in. So if someone feeds in discriminatory data and information, then these algorithms actually also will generate some of these discriminatory results and responses. And this actually advances some of the existing inequalities and discrimination. Think about gender stereotypes. People may be discriminated based on race and religion and ethnicity. And this has been fueled. If you take it to social media, people are likely to advance some of the existing stereotypes discriminating against a particular sect of people, a particular sect of communities, and this raises concerns on an infringement to this particular right on equality. Think about digital redlining. I call it digital redlining or digital exclusion. Vulnerable groups, just like I had pointed earlier, are disadvantaged at the advancement of these technologies. When the government is introducing digital literacy programs, people who are living in areas where there is no access to internet, people who are living in areas where there is no access to electricity, poor infrastructure, digital infrastructure, they are disadvantaged. And this leads to exclusion when some of the critical government services are being taken online and digitally. People who can't access these platforms are left out. So this is digital redlining. This right is at risk. Let me conclude by pointing out, I have two more: right to education, which is buttressed by various statutes, but Article 53(1), every child has a right to education. And I wouldn't also belabor this because we've had a discourse on that by Mr. Nicholas here. But I would want to point the risk of unequal access to e-learning platforms, unequal quality of education. Think of private institutions versus public institutions. Think of people who have, who come from, let me say, humble backgrounds, who can't access some of these critical e-learning platforms. Universities are moving towards online classes. The Kenya School of Law is offering online classes. What happens to a student who can't access, data bundles, or who doesn't have a laptop, who doesn't have the requisite materials to attend these online classes? You notice it's a risk in as much as there is an advancement towards e-learning platforms. So there should be a conversation around this to reduce the bias and discrimination that is designed even on delivering e-learning resources. I just pointed out the government's plan to roll out the digital literacy program. And initially, as it was starting, laptops were given to particular schools. I didn't see the laptops in my village. And I bet a good number of us equally didn't see the laptops in their village, but we are told that laptops were given, and we saw some nice photos, and we were convinced that it's a better plan. So you notice that when they're issuing out these government laptops for e-learning, a question arises on equality and access. Think of the Form 1 placements that happened digitally. People would find themselves placed at institutions which they didn't select. and people would also miss out in the placement. So this right actually is under threat. And students are also likely to form dependence on these platforms. Someone can write a dissertation based on ChatGPT, and submit a 20, 30, 40-page document researched by an artificial intelligence. And lecturers wouldn't know unless they develop plagiarism checks to, flag out this was done by an artificial, someone who is not human, These are some of the concerns. So students will form some kind of digital dependence, and this is a risk to the quality and ethics and integrity of education. Elections is something that has equally been impacted greatly by digital advancements. And we've had concerns time and time again, election in, election out, about system malfunctions, about failures of the KIMS kits that were brought in to facilitate these electoral processes. We've had discussions around lack of transparency. And recently we've had protests on the server being opened, and there is a demand for opening the server. And you would ask, when the server is opened, what kind of information is to be accessed, and who is this accessing this information? And are there regulatory frameworks around accessing such a kind of information? And what were some of the contractual obligations, rights, and implications around the initiation of some of these projects? And you'd also think around data hostaging, because the Electoral Commission would say, we are not releasing this data. Is that data hostage? And these are the discussions that are within the paper that you would have the advantage of entertaining for your intellectual entertainment, rather. So discussions around various other rights, consumer protection, intellectual property rights, and right to life. These are various fundamental rights that are at risk at the face of these digital advancements. But let me also point out a few of the constitutional values and principles under Article 10. I wouldn't really go one by one, but let me pick, for instance, the right to the value, the principal value of human dignity. And there has been instances of an outcry, people being reduced into attacks and lashes on social media. We all know of the hashtag of Kenyans on Twitter, who are well known for attacking anyone, notorious for attacking anyone on various spectrum, including the Chief Justice Emeritus, who categorically was subjected to this a kind of cyberbullying. The president himself, former President Kenyatta, he walked out of Twitter because of these instances. So there are questions really around human dignity still within this. There is a case that is ongoing on the Meta Summer case, whereby the legal advisor of Amnesty International was subjected into various Facebook posts that would threaten him, and that would, he would post exposing the human rights violations while in Ethiopia. But he received a barrage of hateful posts from Facebook, threatening and intimidating him. And this raises concerns on human dignity, even within these digital platforms. So how do we mitigate some of these risks that are posed within the advancement of digital technology? I suggest that we need to take a proactive approach. I know there are debates on whether the law should be reactive or proactive. I say that we should be able to anticipate these developments and, initiate this proactive approach and a multidisciplinary approach where we will incorporate technical expertise and various stakeholders to get the nuance of particular sectors of emerging and emerging technologies so that we are able to mitigate some of these risks. Some of the measures that I propose: we need to establish regulatory mechanisms, legislations, policies, institutional frameworks and institutional regulations for some of these nascent areas. Think about artificial intelligence, for example. Think about data sharing, blockchain, financial technology. And when, in the advent of the Data Protection Act in 2019, some of these nascent areas had not emerged at the onset of the data protection, which we base our reliance on greatly in these discussions. So there should be a development, an anticipatory development of these legislations that are wholesome and whole-encompassing. So think of the e-government platforms that are being set up. Is there a legislation to regulate them? We have the Konza Technopolis that is coming up as a hub for digital development in Kenya. What are the specific regulations around that? Electronic Transactions Act, we have a lot of e-commerce happening in Kenya. And you'll notice we have a diversity of laws regulating, but there is no, a specific kind of regulatory framework or statute or policy in these nascent and emerging areas. Artificial intelligence, financial technology, blockchain. So there is a need to establish legislation. And tied to that, we need to review and reform the current regulatory and institutional framework. And here I suggest harmonization of some of these regulations. Let me pick data protection. We have various regulations. We have the Data Protection Act scattered far and abroad. But there is need to harmonize some of these regulations to ensure centrality, and ease of understanding what are the rights and obligations in various circumstances of digital development. So on harmonization, we have the ICT protection infrastructure, and on the other hand, we have the Computer Misuse and Cyber Crimes Act for 2018. All these appear to be covering one and the same thing. There needs to be a harmonization of some of these regulations. Thirdly, we need to implement the current regulatory framework. There is a problem on implementation. And on implementation, I would also touch on enforcement. There is a gap on intending to develop more framework while failing to implement the current regulatory framework. Issues around data protection. Let me pick an example of the fines and penalties within data protection. You can pay a fine up to 5 million shillings, and maybe 1% of the 1% of the annual turnover. So the maximum amount is 5 million shillings, and the penalty is, in the case of an undertaking, 1% per annum of the annual turnover. What would make a big data company not to breach and infringe on private data? Because, the fine is 5 million shillings. Recently, the Office of Data Protection Commissioner fined Oppo 5 million shillings. What is 5 million shillings to Oppo? At the expense of, infringing personal and private data. So some of these enforcement mechanisms should be more retributive to ensure that in as much as we have the current regulatory framework, the enforcement mechanisms should also be clear. Issues on implementation are also unclear. Think of the digital literacy program, where the government rolled out laptops to various institutions and schools. There was not a clear implementation framework, and that's why the project stalled. So there is a need to review and reform the current regulatory and institutional framework. We also need to think of awareness. Awareness here, including digital literacy and making citizens to understand their digital rights, their e-government services available. This is how you access them, because many people are not really aware of their rights and their obligations. And this actually ties up to the aspect of enacting clear and robust regulatory framework to ensure that even those who interact with these digital rights, they understand what are their rights, what are their obligations, what are the enforcement mechanisms, and any other recourse in case of infringement. Lastly, I propose research and development to ensure, digital inclusion. Digital inclusion in the cases of marginalized communities, where they can't access internet, where they can't access electricity. There needs to be research around these areas. How do we ensure that the projects we are initiating to serve and enhance and promote human rights, they are practical, they are pragmatic, and they are, sustainable in terms of developing them. Lastly, there is a need to provide adequate digital skills and human capital, and this would enhance capacity building in public servants and the citizens and even the ICT professionals. So what are some of the gaps and the limitations within the current regulatory framework? And I think I have highlighted most of these issues. Just to point in passing, first, we have laws that appear to be, irrelevant, and they lack objectivity. What do I mean? You notice the process of enacting some of these statutes. They are more of political, and it's very unclear on public participation. Some of these are actually, most of them are presented in an omnibus. So there is no critical attention that is given to specific regulations. So the law has already undergone profound transformations in response to the digital explosion that is happening, but there lacks an equilibrium. So questions on irrelevance, questions on the interface between human rights and the digital advancements, the freedoms being asked, and these questions arise more as we see advancements in regulations, advancements in digital technologies. So this is a gap that should be fitted. You would notice still on the Data Protection Act, there are criticisms on vagueness, on issues of sensitive personal data, on data sharing, and these are issues that should be considered, because the more technology develops, the more you realize that the scope of some of these human rights expands. Who would have thought that the right to privacy would expand to include, data protection and right to access internet, right to various kinds of digital rights. These are things that ought to be considered within the framework. Secondly, insufficient legal framework and lack of a clear implementation framework. So there are inadequate enforcement mechanisms. There is an increase in the uptake, in the utilization of biometric data, but at the same time, there is not a clear guideline in terms of legislative framework to operationalize and safeguard some of these biometric data being taken, save for the Data Protection Act and various other statutes which can be brought together to buttress this fundamental right. There is also a gap in the implementation barriers. When you consider the issue of e-citizen, which was essentially established by various legal notices, there are unclear rights, unclear responsibilities, unclear obligations to the citizen, to the government, and this raises issues and concerns around implementation and within the unclear framework that is there. Lastly, the biggest gap that I consider is the political climate. most of these developments in technology, especially within the government, they are fueled by the political climate. Think about the Hustler Fund. You know, it's something that has come with the government that is in place, but how sustainable is it after this current government? Let's go back to the Big Four agenda, which included, you know, rolling out laptops to institutions. It faded with the previous regime. And you notice the political climate has even an influence on how these regulations are brought up. So still back on the to the Hustler Fund, according to the Public Finance Management Financial Inclusion Fund Regulations 2022, the government must appoint a board of directors and a CEO to oversee the Hustler Fund. This was not the case when the Hustler Fund was established. And actually there are concerns and even issues and cases around this. And we are curious to see how the courts will consider. So the fifth gap is on conflicting and overlapping regulations, institutions, and policies. You will notice a lot of duplication and a lot of multiplicity in terms of policies, regulations, and laws. I see these gaps and I think of the opportunities that are available for lawyers, for policymakers, for stakeholders. What are some of the opportunities that are there to advance human rights, constitutional values, and principles in this digital space? I'll just mention swiftly, there is an increased uptake in technology. There is an increased adoption in issues of ICT at the workspaces, you know, in the government, in institutions. This is an opportunity to ensure that some of these digital rights are met and they are actually spread out to everyone in terms of equality of access, in terms of enforcement, in terms of creating a framework around it. There is an increased participation in the private entities. You would see companies like Safaricom involved greatly in, you know, sensitizing issues of how do you use M-Pesa, for instance? How do you use financial in the bit of financial technology? How do you access some of these funds? And this is a very big opportunity, even for players within this sector to tap into. I would also highlight litigation on digital rights. Think of the Nubian case. There has been a lot of litigation around digital rights, a lot of litigation around data protection, with the ODPC giving their inaugural determination earlier in the year. You will notice that all these are an opportunity for advancing and enhancing these human rights. When lawyers, when people take it to the courts, and you know, some of these human rights become so apparent when they are taken to court and litigation is instituted. That's when even a clear implementation framework comes up. Think about the advocacy work. There are a lot of organizations that are advancing some of these rights. There's a case that was instituted by Katiba Institute and Yashpal Gai on Huduma card, which the government wanted to issue Huduma cards without conducting the requisite data protection impact assessment. So some of this advocacy that happens around are an opportunity to enhance the implementation and the fulfillment of these fundamental values, rights, and principles. There's an opportunity to come up with comprehensive regulatory framework. There is an opportunity for an increased government support because, like I began by saying, the government has demonstrated intent to further some of these accessing some of these digital services, even in the e-government platforms. So I would conclude by pointing out that there is a very complicated, rather, interplay between digital development, digital technology. In this current digital era, there is a very complex, interplay with human rights, constitutional values, and fundamental principles. In one hand, we see an advancement. On the other hand, we see a risk of various challenges and negative impacts that are threatening to erode and infringe some of these rights and constitutional values. We need to have more of this conversation. We need to lobby for more policies and implement a robust framework in terms of regulation and in terms of enforcement to ensure that digital technologies are equally at par. Though debates are there that the law would sometimes lead to social change, but at some point, social change, including advancements in digital rights, would equally necessitate some developments in the nascent areas that are coming up, even within the regulatory framework. With this, I invite you to consider the paper when it comes out, and thank you for listening. It has been my pleasure.
Thank you for that exposition that brings out the complex relationship between technology, human rights, and our constitutional values and principles. Thank you once again, Caleb. Let's clap for him. So we'll take questions for our three presenters so that they can respond, and then we can get to the next part of the program. Well, as I can begin also. I had some questions for Ms. Moi. You made a statement that I was curious if you could expound. You said, how can you protect somebody who doesn't want to be protected or is ignorant? And I think it ties in very well with your point about digital literacy and how the government needs to go further to ensure there's digital literacy. But in that regard, how do you enforce this as a government to ensure that your people know what their rights are, how they should be protected, and to protect themselves? Because in the digital space then, we are very vulnerable as individuals. Unless the government is able to safeguard us, you're right, it is hard to protect somebody who, I can't say doesn't want to be protected, but may not have enough information to protect themselves. Perhaps you can start with that.
In response to the same, maybe my take was a little bit harsh because of we know of the law that equity of the law is no defense. No ignorance of the law is no defense. So in the same breath, there goes my take that you're not supposed to share your information arbitrarily, like all over the place. It goes to you sharing your personal information in a post, maybe because you want some people to take you in a certain way. So when it comes to that part, that is where I would say that maybe if you do not respect your privacy, how can someone else enforce the same for you? In the other aspect of someone who doesn't know of their rights, I said one of the impacts of the digital space, it has really enhanced people knowing of their rights, their private rights, their rights enshrined in the human rights, in the Constitution. So in the same breath, my comment would apply to that person who willingly shares the information, knowing very well that this information will be used in a manner that will infringe on their private rights.
Thank you.
Yeah, so probably the government will enhance on the knowledge.
All right. Thank you. We can take the question at the back, and then we'll proceed to the gentleman on my right side.
Good evening, everyone.
Good evening.
My name is Caroline Saranga, and I have a question to Mr. Oginga. When you talked about the internet being a fundamental right, if a bill was to be passed today that it is a fundamental right, will it be a disruptive force in the digital economy? And is it going to lead to more crimes in the digital economy? And if yes, how then do we achieve the internet as a fundamental right at the same time we protect the digital economy? Thank you.
Thank you. We can take from this gentleman on my right side. And then Nicholas.
Thank you very much, Umar Dalmas. I have a question to Mr. Oginga Ochieng. Yeah, it's very simple. We know very well that justice is not free. It's not free, but it's also not expensive. So to attain or to propose to make a right to internet a fundamental right, given the fact that we know how expensive it is, because some people cannot afford it, while proposing it to be a fundamental right, how will it be achieved, and on whose expense will it be? Yes, that's my question.
Thank you. Nicholas, and then Liz at the front.
Yeah, I have a question to Mr. Arnold, and thank you for the substantive presentation, because it's changing the narrative in terms of how we are looking at internet and its accessibility. So in classifying the right to internet as a human right, because that's what you've proposed. So is there somewhere where we can classify in the sense that because we have a category of human rights where we have, for example, social and economic rights, we have political rights, and so on and so forth. So is there a category, is there a place where we can categorize? Because our traditional knowledge of human rights is that, because even my understanding and idea on this has always been that it is hinged on other rights, so that interfering with the right to interfering with the internet connectivity and so on and so forth will have an effect on how you exercise or how you enjoy other rights. So that's the concern. So is there somewhere where we can classify it, or it will be a standalone kind of a right? And then maybe generally your thoughts on this, against whom will it be applicable or enforceable? Is it as against the state, as against the internet service providers, or just like every other right where you can apply it horizontally and even vertically? Yeah, thank you.
Thank you. Since there are 4 questions directed to Mr. Oginga, we'll give him an opportunity to respond, and then we'll take the question from the front, from Liz.
Thank you for the questions. Now, for the first question, on whether the recognition of the right will actually disrupt the digital economy, my answer is in the negative. In fact, to me, I say it will bring in more certainty, because now it will provide a structured regulation, so that in terms of, even if you interfere with the access to the internet as a right, there are proper mechanisms for the government to interfere. So you'll have to fall back to Article 24 of the Constitution in terms of limitation of rights. Then secondly, and closely related to that, is the aspect of how do we incorporate it, infuse it into our legislation. So that to me, since this is something pertaining to the Bill of Rights, we'll have to go the constitutional amendment way, so that you have to fall back again to the clauses under Article 255, 256 on constitutional amendment, so that since given is it's something that will disrupt the arrangements and the arrangement and the institutional mechanisms of fundamental rights and freedoms in Kenya, it will have to go through the referendum way, because this is one of those protected rights that has to go through the referendum channel, so that it will entail the enactment of a specific bill, specifically identifying access to the internet and its key components, and perhaps to anticipate even instances of limitation, or if there is need to also have any supporting legislation. So ideally, it will be through a constitutional amendment bill. Now, on to the second question. The question is, how do we enforce these rights? Yeah. So that first, let me begin by answering the last question before I go into enforcement. Now, for the last question, why do we categorize access to the internet? Now, going by the judicial pronouncements and interrogation, the courts have largely linked access to the internet as an enabler to right to education, to trade, freedom of expression, privacy, and all. So that largely it has been viewed as an enabler to e-services and various governmental functions. So that to me, it will be placed under socio-economic right. And I say so because we look at how the government enforces socio-economic rights. If you look at the decision, look at Satros Ayuma, look at Mitubel, look at Michael Okwenda, how the government has dealt with the aspect of availability of resources in terms of provision of education, in terms of relocation, evictions, in terms of access to medical healthcare, so that as a socioeconomic right, you look at again Articles 19, 20, and 21 and 23, so that we have the remedies in terms of structural interdicts, where the court intervenes and says the government should put in certain policies and measures. It has happened. Look at Mitubel decision, where the courts actually compel the government to put in policies to govern evictions in Kenya. So that one of the approaches will be, in terms of enforcement, in regard to structural interdicts. Then, secondly, other than structural interdicts, it will be a direct case of violation. So that if you deny me access to the internet, that is a clear case, even without structural interdicts. Now, there will be a higher obligation on the state to ensure the realization of the right. Now, this is even more interesting because if you look at the CBC new curriculum, there is the aspect of digital literacy. It is one of the compulsory units. So that as we head there, now the government per se is committing itself to ensuring the realization of digital literacy as one of the key components in education. So that taken in totality, I can still argue for realization of the right to education, realization to the right to digital literacy, and finally, and more importantly, as we know, socioeconomic rights, it is they are always realized progressively, so that if you look at the decision from 2013, the question was, the courts were reluctant to enforce, and they said it's a progressive process. In another project we're working on, we've addressed the issue of how long is progressive realization. Yeah. So how long does it take? Is it 2 years? Is it 3 years? Like after 10 years, can you still come and say this is a progressive right that we'll deal with in the near future? But the good thing now is that most of the steps being taken by government call for an immediate enforcement of this right, so that I can now complain I cannot access e-citizen services. First of all, because I do not have the digital literacy, I do not have the resources, we do not have electricity, we do not have the transportation and means to even access the Huduma centers and all. So that with these arguments, as a human rights practitioner, I have a direct channel to even enforce it immediately, and it's through that I can seek structural interdicts. Yeah.
Thank you very much for that. response. We'll take 2 more questions, one from Liz and at the back, Mr. Kaniero.
Thank you. So I have a question for everyone. And so for Diana, I left this bank 10 years ago and they still keep texting me. Even if I've told them not to stop, I still get these messages. Can you comment on whether some institutions should be compelled to delete data or stop texting people? Or perhaps we could consider adopting rules like the GDPR, the General Data Protection rules for the EU, which require people to specifically opt in if they want to receive certain information, as opposed to being bombarded all the time. Yeah. And the second question is for Arnold. So could you comment, is there a general right to information? And if we can dig deeper, what information? Because there is some information that a lot of people have got no business knowing. And perhaps we could be hinging this right to access to the internet to the right to information. And then when you're talking about access to the internet, perhaps this should be on a case-by-case basis, because you need to consider things like region, economy, is there electricity security? So perhaps in your recommendations, you could be thinking about the right to access to the internet being something that is decided upon based on a case-by-case basis. And finally, for Caleb, so you brought some discussions on social media. Could you comment on situations where people, there are certain groups that are being created in Facebook and your ID is put there, your number is put there, even where you live is put there, and people are invited to send salams to you. What recourse within the law do certain people have where the information is put in the public domain, and how can they seek justice? Thanks.
Thank you. We can take the question at the back from Mr. Kaniero.
Good afternoon, everyone.
Good afternoon.
For me, it's not a question, it's rather a controversial comment on the discriminatory purposes Caleb has talked about, that data or AI may infringe. I'm of the idea that AI does not discriminate against people at all. AI merely reflects what is fed in the internet. So if you say that AI is discriminatory towards certain group of people, AI actually reflects what is in the internet about certain groups of people. AI will never reflect, will never discriminate. For instance, when you ask AI, give me an example of a certain political scene in an African context, it will reflect what the West thinks about that African country or context. Why? Because Africa as a country or as a continent has not contributed in the development of AI in any way. It is in this present time or in this near future, AU is actually considering coming up with a AI-driven policy whereby we are trying to draft regulations that will govern AI development in Africa. What basically I'm saying is that Africans and Africa as a continent, we are more of consumers and not developers in some sense. So saying that the right not to be discriminated may be infringed in some extent may not actually suffice when it comes to artificial intelligence. Those are my remarks.
Thank you for your remarks. And while we are there, we'll begin with you as you respond to what Ms. Oyange here had asked you. I don't know if you caught that question.
On the right to be forgotten.
Yes.
Yes, I've gotten the question when she has asked when you receive messages from supermarkets after you've bought goods and then they keep on sending you messages. Is that it? Or
that
a job?
question?
Which
that one was Diana's question.
Yes?
Yeah. Did you have a question for him?
Oh, okay.
Sorry. All right.
Yes, as enshrined in the Data Protection Act, there are instances in which a data controller has been forgiven, quote unquote, from deleting a person's data. And I believe I mentioned them. One, I think in that category, it may fall under the legal perspectives or legal repercussions. It is okay if that data controller continued handling that data for you, because in the future, you may sue, or you never know what happens. They refer back to the data that they have on you, on the times you logged in, on the work you did, your details and whatnot. I do not say it's okay for them to continue sending you text messages if you have already asked for them to stop, because under the same Data Protection Act, it is the right of the data subject to ask and request a data controller to remove the data, to remove any sort of data that the data controller might have on the data subject at any given point. Is your question answered?
All right, it is answered. We'll take one last question and then we conclude that session for question and answer. So we'll take your question. Mm-hmm. Yeah. Okay, so you want him to clarify, yeah, with the follow-up. So let's start with Caleb. You can respond, and then we'll finish with Oginga.
So, about Facebook, just for the record, I am not in Facebook. So I'll be giving an amateur response. So someone takes your personal data, your ID, your personal credentials, and posts them in a platform, and even invites people, to send wishes to you directly. One of the principles within the Data Protection Act is consent, to your data being shared, your data being, placed in such platforms. And so there could be grounds for, let me say, private data infringement. And one can lodge a complaint within the office of the ODPC. But a very interesting circumstance with Meta is that recently there's been a case of Meta subjecting its employees to poor working conditions. Meta argues that Kenya lacks jurisdiction to listen and even pronounce judgment in that circumstance, because Meta is not based in Kenya. So for Facebook, I think regulations still need to get to that extent of regulating some of these big data processors, people who share data, people who control some of this data. Still on the Meta Summer case in Ethiopia, there was a professor who was murdered due to this, algorithms that suggest profiling messages and even posts within the Facebook. So the Sun has sued Meta, and still the same argument. Why were you guys delaying in, pulling down this information, pulling down this kind of harassment, pulling down this kind of intimidating and kind of abusive posts? Meta still argues that, within this region, Meta only has one company that, regulates what is being generated as these posts, who are Sama. So Sama is the only company within this case. So there are arguments within Facebook as to the feasibility of lodging a complaint and actually enforcing. So there's the bigger issue there is actually enforcement, so that if my personal credentials are posted and I did not consent to them, am I able still to pursue to ensure that I still retain my privacy? So yes, there's a recourse, lodging a complaint, pursuing a judgment, and after the ODPC, one has the option also to appeal to the High Court. So litigation is an option, and even lodging a complaint is an option within the ODPC. I hope that satisfactorily answers you. Okay, let me also respond to a comment by a good friend of mine. AI reflects what is existing. If what is existent is discriminatory, AI will reflect what is discriminatory. An example that I interacted with recently on LinkedIn, someone posted photos saying he asked artificial intelligence to give a photographic simulation of people in the corporate world, CEO, CFOs, and of course using animal characters. So the heads were animals, so a fox would be the CFO, a lion would be the CEO, but the body would be masculine. I don't know if you saw that. Exactly. So questions would arise. Are all CEOs and CFOs masculine? No, but it is a reflection of what is happening around us. So my point actually was, there is a risk of advancing, exacerbating, aggravating this kind of discrimination that are existent within the society. So that if what is picked by what is fed to the artificial intelligence is discriminatory, then when you go to ChatGPT and ask it, give me this, give me that, it's language. It's a language-based model, and it responds to the data and information fed in. So if what is fed in is discriminatory, surely it will reflect discriminatory response. So the bigger risk here actually is advancing and even reflecting, in your own words, the existent discriminations. We can have a chat still around that. Thank you so much.
Yeah, thank you for the questions. I feel we need another platform just to debunk and demystify the topic in general. Yeah, but first, let me deal with the last question on the digital divide. My argument, I'll say that in as much as the private sector are moving fast in the adoption of technology, the government is doing the same. And it is doing so. In fact, the government is focusing so much on fundamental services, so that at the end of the day, the person to be held liable or accountable will be the government. But secondly, and more importantly, we have the aspect of horizontal and vertical application of the Bill of Rights, the beauty of our Constitution, so that Articles 19, 20, 21, in various circumstances, you can enforce rights even against these private players. Yeah. So that, for example, if a government service is linked to payment, e-payment through M-Pesa or digital platforms, I can still argue that the imposition of the digital platform, and as you note, there are no options in most government services at this point. You either, some you're compelled to make digital transactions, go to eCitizen, you want to apply for your ID, you want to apply for critical documents, you have to make e-payments, so that the nexus, so that if I'm suing the government, I'll also definitely have to sue Safaricom, because it is among the key major player that has been linked to the system, so that we don't want to go again to the issues of, was there public participation, was there procurement, what was the role, were we consulted before this was implemented? You see, all those are other key issues key fundamental issues, which again boil down to the aspects of where do we incorporate national values and principles of public participation and involvement of the people. So that I'll come with a petition on Article 10 values and simply argue we were never consulted, we were never involved, and as a result, again, I'll link it with my rights, socioeconomic rights. I can't access government services, I'm being discriminated against and all that, yeah? So that ideally, for me, at the end of the day, the horizontal and vertical application of the Bill of Rights comes into play, regardless whether in government or a private sector, in technological advancement. But it's a good observation. I'd encourage you to put a paper on it, because I remember our early classes in jurisprudence. I used to enjoy readings by Hart, Fuller, Bentham. They were writing and responding to each other. It was an interesting way. So I'd really love to have such engagements, especially in these tech talk discussions and discourse, because we have different perspectives, and it would be good for us, academia and practitioners, to move forward and document all this. Now, secondly, on the aspect of the general right to information, and if we link it to the internet and any such limitations, my starting point will be first, access to information, and Article 35 has two limbs. First, it is self-executing, in that the government is under an obligation to publish important information affecting the state. Now, on the flip of the coin, it is not self-executing, and the courts have held as much, so that for certain information, you have to take initiative. You have to apply. It is not automatic that IEBC will open the server for you. You have to apply. But again, the dilemma, because ideally the server contains results, you voted, you're entitled to that information. So should we request for it, or should it be automatic? Yeah, going back to the electoral principles and principles of national values, in terms of transparency, openness, the whole spectrum of electoral principles. So that the question of the server, should we be out there requesting to see our votes, all that? So that this is some of the things being brought forth by technology. So the interplay between national values, human rights, and technology in different aspects. Then secondly, again, we have the Access to Information Act, which now seeks to operationalize the fundamental right to access to information. So that under the Act itself, we have prescribed limitations, which are founded, again, you go back to Article 24 and 25 on limitation of fundamental rights. So that the first thing under the Access to Information Act is that it is prescribed by law, then it provides circumstances whereby access to information may be limited. So that in instances of state security, yeah, and then in instances where the information to be released to the public or any individual may be prejudicial to the economic interests of the country, then again you have to read that together with the Data Protection Act on various aspects and the scope of to what extent can we publish or release third-party information. So just to appraise yourself, I remember in 2019, we argued the port petition case at in Mombasa. It was before three-judge bench, where we had actually sought to obtain information in regard to the privatization of Terminal 2 of the Mombasa port. And one of the arguments, and the court agreed, that we had not exhausted the remedies under the Access to Information Act because we had not made that request and followed the dispute resolution procedure under the Access to Information Act when that right was denied. Now, finally, in terms of implementing or realizing the right of access to the internet, whether we should consider an approach that we deal with it on a case-by-case basis. To me, I would strongly oppose that view, and I'll fall back firstly to Article 27 of the Constitution on the right to equality. So that again, what are the parameters? How do we determine? Then if we go back to the question of resources, first, we look at the judicial pronouncements and approach by our courts. First, the courts have frowned upon that excuse that due to lack of resources, we cannot implement this right. Yeah, so that we fall back on progressive realization of rights, how the courts have handled issues of socioeconomic rights implementation, how the UN resolutions have interpreted the state's commitment, and the question of balancing between resources and socioeconomic rights. So that I will not propose that argument that we provide access to information on access to the internet on a case-by-case basis. For me, I want to go for full inclusion because these are some of the things we are even trying to grapple with in terms of, even if you look at the scholarly works, especially the aspect of a digital divide, because we have people who have access to it and some who do not have access to it. So that if we incorporate again, even looking at it in terms of even the nature, even as we sit here in the room, there is that digital divide. People have iPhone 5, 6, some have iPhone 14. That in itself is a digital divide. Yeah. So that if we go back to the aspect of resources, it will be, we are permitting the state now to politicize that right. So that we are telling somebody in Northeastern, you cannot apply for your ID or passport virtually because of limited resources, but we'll get back to you. In the meantime, you're still dealing with people in Nairobi and all these other regions with resources. So ideally, I'll fall back to Article 27 because it is not one of those permitted discrimination. We have permitted discrimination in terms of affirmative action, which is permitted and understandable in certain instances. But when it comes to certain fundamental rights, you cannot draw the line. So my argument would be we stick to 27, equal access to the internet for all. Thank you.
Thank you to all our presenters and our participants. Let's clap for all of us. That marks the conclusion of day 2 and also the conclusion of our conference, the 4th annual Kenya School of Law conference. I would like to invite Mr. Kuluba to give us the concluding remarks. Karibu.
Good evening, everybody. Thank you for everything, Naserian, for coordinating this important exercise, which is annual. I wish we could have more time to hear some views from you who have participated as facilitators and also as participants. Yeah, but because of time, we will come to the end. I was very keen to hear about creation. Is it creation of a new right or recognition? I'm not sure whether it's creation. This one of rights to internet. I think in my house it is now a fundamental right because when I delay paying for Wi-Fi for a day, people want to go to the street. So I think it qualifies 75 years after the Declaration of Fundamental Human Rights in 1948. Then I think in 1978 or something, economic and social rights. Yeah, so these rights keep evolving, and I'm sure internet is one. If there is no internet, then you can't communicate. Now, don't you think it is important? It's like muzzling us if we don't have internet. So thank you, very informative discussions we have had since yesterday, very well researched. We look forward to reading the full papers, of course with the input which has come from comments and questions. They point to some areas that maybe you need to address. I was just thinking when we were discussing that the way society has moved towards transparency and accountability, like our Article 10, it has also accelerated encroachment on the right to privacy, because in the public sector, we call somebody for interview, we start asking about their income, their wealth, education. I remember a certain judge of the Court of Appeal was embarrassed when they were questioning his academic credentials in 1970s. And, this is a person who has children and grandchildren. Now they are treating it as a matter of public now, then the interview maybe is before 6 or 7 people, but then it is digitized and then it is distributed to all over the world, and you can get it on the Google, on the YouTube for many years after that. There's that scenario. So there are many issues there. So what is, I was just thinking, is public interest to know this person during vetting more important than the right to privacy of this particular person? I think there is a balance. Maybe one day we'll have public interest as a fundamental right so that we can now put them at the same level. Otherwise, sometimes they conflict. Now, let me close by saying some few things. Those who have facilitated, I wish they could say 1 or 2 things before we conclude. Naserian, is one of you wish to say something? Those who are in the faculty, you could say something before I conclude. Just come.
Good evening, everyone.
Good evening.
My name is Cornelius Lupao. I'm fairly, perhaps the youngest faculty member. And I came in, and this conference was being arranged, and I was looped in. I have had occasion to go through most of your abstracts and the advanced versions of the papers that you have eventually come to present here. I can confess that I'm challenged. When I look at your faces, most of you are still students here. Others are still doing internship in chambers, wherever you are. The kind of things you are thinking about, the way you are writing, even the things you raise, then I'm like, perhaps, I think at our time when I was here, I don't think we even had WhatsApp. Naseri, and I think you are in the same bracket or around there. Is it that even this so-called internet and digital issues are making people more cleverer or are making them access more information? Because I don't think I will have written papers to the extent and quality and content of what you guys are presenting here. And whereas you are challenging me, on my part, I want to encourage you guys that seize that opportunity, run with it and don't look back. That is how people carve their niche. I think 5 years down the line when we come here and we talk of Dr. You are called Okinga. You are one person I will not forget because of the name. So when we talk of Dr. Okinga, 5 years to come, you will be so much delved into your space such that you will be lacking time to go around the world and disseminate that information. And I want to tell you from a perspective of somebody who has worked both in government and having run some private consultancy, and now even in this institution. There is no limitation to the area to which you can become a professional in this legal field. And no one should tell you that there's anything called being saturated. Once you carve yourself out of some small space and you stand out, you will be refusing some consultancies because you don't have time. I have tested that. And you guys have a blank check in terms of time ahead of you. I want to say, please don't drop this ball. What you have picked, what you have demonstrated here, if someone came here and you didn't introduce yourselves as being students or doing internships, someone would think you have actually developed yourselves in that space for some time. I'm challenged. That's all I want to say. And perhaps as we retreat back to take the lessons and organize for another conference next year, definitely whichever field we will be looking at, we won't forget your contacts. And as, I don't know whether he has touched on it, but I'm sure he'll be touching on it. We intend to develop a fairly respected law journal for this school. Of course, the name of this school, wherever it is mentioned out there, people should turn heads. And one of the things that should put it on the map is a law journal. And these articles of yours, go and from the feedback, improve from them, come forward where you want further guidance. Let us compare notes so that they see their place in that journal. Because for it to get to the journal, there will be a peer review board within here, and we shall also have external reviewers. And some of the places we have been when we want to scout for those reviewers, we go for the best. Like I was giving them an example of Justice J.B. Ojwang, professor who you all know. At some space, we gave him some articles written by professionals, far more experienced and older than you guys. And he thrashed all the papers. Of course, you want that kind of challenge so that whatever you write, let it get published, even if not here, but elsewhere. For those of you who are pursuing masters and higher levels, you know a lot of academic institutions now demand that you must have published at least a paper in a renowned journal for you to graduate. So this is the space. You guys get the challenge. Thanks.
Thank you, Cornelius. Cornelius is responsible for research, and these things will fall in his section of CPD. So next time, I know you'll be seeing him more. Thank you. Let me just appreciate as we come to the end, because we have discussed the theme. This theme is very appropriate at this particular time after we just emerged from COVID-19 law in the digital age, and the sub-themes, law, ethics, and social media, electronic justice, the digital space and fundamental rights, legal education in the digital age. Yeah, all the themes and the main theme and the sub-themes have been addressed, some with more writing than others, but we really appreciate. So as we come to the end, we hope that we have achieved the objectives of this conference, and being to generate knowledge, to interrogate issues, and possibly influence reform, new thinking, national policy, and above all, law reform. We are a legal institution, so we hope that some of the issues that have been raised here will lead to that. I said that we intend to publish those articles that will meet the school's editorial policy. You will be guided on that. And the school has been having a journal called African Comparative Constitutional Law Journal, which is published by a South African publisher called Juta. No, this is available by subscription. You may not have seen a lot of it. So we are planning to have, starting with this conference and the publication, the presentations that will meet the criteria, then we'll have the first volume of the Kenya School of Law journal. So we hope that you'll refine, as you'll be guided, refine the articles in accordance with the editorial policy. Then we hope to publish as soon as possible. And this will become a regular thing. So allow me to thank God for leading us. We started here, we pray that God guides us, and we have seen us through up to now. We didn't have a lot of technical issues. I want to mention the chief guest, Commissioner Immaculate Kasait, who started us off. We had another guest, Major David Kimemia, on behalf of Colonel Evans Ombati, who was talking about cyber security issues. All the speakers, some of you are here, you have just concluded. We want to appreciate your effort
and your time to come and present. First of all, to research, then to present today. We know that it requires a lot of commitment to do so. As Cornelia says, a time comes when you have a lot of knowledge, but you don't have time to write. So you better do it right now. When some of you are young, or most of you are young, you should be able to publish at this time. The participants who have been here for the 2 days, both who are attending here physically and those who are following online, I want to appreciate you for attending this conference and for your contribution to the discussions. The moderators have been very effective. Mr. Kefa Simiyu, have Naserian Sitelu, who is also the coordinator of this conference, Cornelius Lupao, and Ms. Sandra Soy. They have handled very well the various sessions and the panels that were had earlier. So we want to appreciate the panelists, want to appreciate the presenters and the moderators. I also want to appreciate the rapporteurs. Their rapporteurs, usually they are silent, they are taking notes. Agnes Mwai and Jen Gidinchi have been ensuring that they capture notes. We must learn from this. Even as we present, there are other things that may not be in the articles, but will be in the conference proceedings. So we appreciate that. Also, communication team, have my sister here, Lini, and her team, the communication person, our communication, corporate communication officer, Ruth. Thank you so much. The designing of this place, that is within her domain, and she has been very supportive since the beginning of this conference. Of course, the marketing officer was also involved here. Our sponsors, we had a few sponsors, Cooperative Bank of Kenya, Council of Legal Education, and Oslo Solutions. Thank you so much for supporting this conference, and we know that maybe this notice was not long enough, but they came out to support in the way they have done, and we hope that we'll work together in the future, the near future. Hospitality, of course, they have taken care of us. Administration department, ensuring this place is habitable, and the facilities. We wish to thank the conference committee that planned from the development of the theme and the sub-themes and all the issues that pertain to the conference. There was a committee which has been very active for a few months. Thank you so much for your work, and the Secretariat also for facilitating this training. We had the school department, supply chain, finance, and other staff who have supported us. And also now I wish to also thank the director, because all these things cannot happen unless the director approves our plan and approves our theme and also provides for the budget. So the school, as a school, we are committed to encouraging relevant research in the areas of law and administration of justice for the betterment of the laws and relevant policies. So we shall make the papers available through publication, the journal, as I said, and we request the authors to refine them and consider the input from this conference and submit them as soon as possible. I hope that you will be in touch with us in that regard. Otherwise, I want to thank everybody on behalf of the school, on behalf of the director and the board that, for attending this conference and for your contribution. I all wish you a happy Easter as we go into the long weekend. I would like to quote somebody here as I conclude, called Miss Margaret Beckett. She was secretary, foreign secretary of the UK in 2006, 2007. She was also the first woman to hold the post as secretary, foreign secretary. She also served as the party leader of the Labour Party. also the first woman to hold that position. Now, she said he's talking about technology, that there are people behind. We have talked a lot about technology, but if the people do not do things differently, technology will be destructive. So she says, humankind has the science and technology to destroy itself or to provide prosperity for all. But while science offers us these opportunities, science will not make that choice for us. Only the moral power of our world acting as a community can. Yeah, only the moral power. Talked about electronic justice, that you can have these figures, accurate capture of digital things, but if the person behind the transmission, behind the generation of that is not upright, is not a person of integrity, then science will not be useful. So it will not serve the purpose if we can corrupt it because of our own other objectives. So thank you so much. May God bless you. As we hope that we'll be in touch. I thank students. Sometimes we forget to say that they are lawyers. You know, students here are lawyers. They are qualified lawyers. Now we focus more on students. You know, when you say students, the word lawyer disappears. But now these are lawyers who have qualified and they're just finishing up. So we thank you for contribution and for coming out to compete very favorably in this kind of subject. And we wish you all the best even as you continue with your studies. And those who are already out of this place, we wish you all the best. So for the online audience, we thank you all for your patience with us until this time. Thank you, Naserian. Do you have something to say before we? Okay, thank you. So I think we can clap for ourselves. I think let us clap for ourselves. Okay, then for the facilitators, moderators, then for Naserian here, and the rest of the team that has supported this conference. Thank you, God bless.
Thank you. We can stand up and pray. Everlasting Father, we exalt your holy name. Thank you for your goodness and mercies towards us. Thank you for your guidance and your protection throughout this conference. And thank you for all the deliberations that have come up from the presentations. We ask, Lord, for the wisdom to implement what is useful and to be bold to go forth and be agents of change in our individual capacities. We ask for your guidance even as we go back to our various homes. And we ask, Lord, also for the strength to continue with our work tomorrow. May you be exalted and may you be praised. In the name of Jesus, I pray and believe. Thank you. Tea is served. Enjoy.